into the Karen Reed case has reportedly ended. Now, I initially wasn't sure what the federal investigation was into. Was it into Karen Reed, whether or not she murdered her Boston boyfriend, John O'Keefe, or is it a federal investigation to law enforcement? But it's been reported, I think, since like a week or two now, or maybe even before then. But it's been reported that they were investigating into law enforcement. So the federal investigation has ended. And apparently, I don't know why he's going crazy over here. Cheryl says hi. And apparently, no one in law enforcement has been charged. I don't know if it's like a yet or it just they haven't been charged. But today we're going to come back to Karen Reed's hearing. Last week it ended abruptly, and I didn't live stream with you guys, but I was watching it. Oh my God, it was getting so intense. I did do a video about it, recapping everything for you guys. It was for the ARCA experts. The state wanted to exclude the ARCA experts from testifying in trial number 2. And a lot of people were like, well, why? Excuse me. Is it because they think the ARCA experts aren't qualified experts? No, that's not the reason why, because they were. They felt like they were. They felt like one of the best experts that testified during trial number 1. It's because the state is alluding to the fact that maybe the ARCA experts and the defense prepped for the trial number 1 when they told Judge Cannoni that they did it. So that's like a misrepresentation to the judge. And then also there was, excuse me, what are you doing here? Why are you destroying stuff? Cheryl says hi. I don't know. He's just really excited today. No. Calm down. Calm down, sir. Hi, good morning. How are you doing today? Hello. Jesus. And it's still morning here. Okay, my throat is like, back to the ARCA experts. I lost my train of thought. What was I saying about the ARCA experts again? Oh, and then also there was a federal court order that the defense, the state couldn't prep with the ARCA experts. So the defense could be in trouble, but we'll see. Right now, the defense is going to go up there and explain to Judge Cannoni what happened. And let's see if it's going to be serious or not, or if it's a nothing burger. Because when last week's hearing ended, it was like super abrupt. They did a 30-minute recess. The judge came back. And then Hank Brennan, the special state prosecutor, came back and corrected a huge major thing, where he said that some of the emails are provided to him. He said that it was originally provided by the feds. And then he came back after break and he was like, well, actually it was provided by the defense. So the defense, they are very smart people. They're not just like newbies in this job. They know what they're doing. So it seems weird to me that the defense would provide evidence to the state that would basically put them in hot water. So there has to be a good explanation, I think. I'm waiting for the good explanation from the defense team. So that's why we are here today. This is part 2, since we had a major cliffhanger last week. So we did do a video recapping everything, and I included a bunch of videos, gluing it all together for you guys in case you guys want to know what was going on. But yeah, I'm very excited to be here. Good morning. I hope you guys are doing well. And it is very sunny here. Very sunny. It's getting so warm now. Hi, lady. How are you doing today? I'm doing good. Hello, hello. Hi, Senja. Hello, it's been a while. Hi, Senja. Hi, Sarah. Hey, beautiful lady. Is it warm and sunny out there? It is. It's a little too warm. I think we're already hitting 80s this week. I don't know why. It's only February. All right. So I actually thought this hearing was going to happen at 9 a.m., but it just started just now, because usually I like waiting until it's a little bit later to start. That way we can catch up and we can speed things up a little bit. But yeah, we're right in the very beginning in the morning, and Shiro is very active today. Shiro, come here. You want to do tug of war? I guess we can tug of war. We'll do tug of war while I have the mic muted and we watch court stuff. Come here. I thought you wanted tug of war. Here. So if you guys see me dancing around in the background here, it's Shiro. He's very active right now. Okay. Judge Cannoni is back. It looks like she's got her posture together. Last time when she ended the court session, she was like, I don't know, she was like running out of breath. She was like huffing a little bit. I was like, Judge Cannoni, are you okay? So let's see if it's going to be anything crazy today. I got my subtitles on, and I might need to boost audio. Hi, Joseph. Hello. High 50s here. Oh, that sounds like perfect weather. I want it to be like 50s, 60s. I think 80s right now, it's a little bit too soon. I'm not ready for summertime yet. Let me know if I need to boost the audio, but I think, actually, I might have to boost the audio. Let's try.
You are unmuted.
No, the other side, too.
Oh, I don't want this one. Volume master. Oh, I like this one. Yes. Hey, don't eat that. Don't eat that.
All right, so I apologize if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with what's in the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Table of contents.
Yes.
Good, okay.
I think we can make it a little bit louder. Ow! Man, Cheryl's strong. He's like 30 pounds. How are you this strong? Well, actually, no, you're 35 pounds now. So we have Mr. Alessi here. This is the new attorney that was hired. I think he's a New York-based attorney. I don't know if Mr. Alessi is going to be addressing the cliffhanger from last week because he was not an attorney during that time. I was assuming maybe Alan Jackson would, or maybe even Mr. Yannetti, but they could be arguing something else. We'll see. Good morning, Mr. Alessi.
May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components. And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to start with the
Wait, why is the audio... Is the audio low for you guys? I feel like it should be a lot higher, but for some reason it seems low. Hi, Tam. Good morning. Tam, I saw you in... was it maybe Lawyer You Know's chat, maybe? I saw you somewhere. Hello? Wait, is this new? Hold on a second. Why is this not working? Give me a second. How have you been? Let's try the other. Why do I have so many volume stuff on here? Let's just do volume booster.
notebook that I handed to Your Honor and
Oh,
to
that's
Mr. Brennan this morning. The notebook is purposefully in chronological.
Why is the audio so low? Hold on a second. Settings. Is it me then? Maybe it's me. Are you guys having a hard time hearing it too? I'm looking at my my audio meter. You can't eat that, Cheryl. Wavelength stream. Let's see. Microphone. Wavelength monitor. Nope. Get down from there. Okay, let's try that. It's weird. I've never had audio issues before. Maybe the original video is just really, really low. It's pretty low, right? What? It's okay. We have all the time to catch up. Okay, I'm gonna boost it some more. Well, actually, I want to see what it sounds like normally. Okay, so this is what it sounds like normally, right? Should we go to court TV? Maybe I gotta go.
Chronological order.
Okay, so this is low.
The notebook is in chronological order because I believe the best explication of the facts and what those facts mean come from a proper chronological presentation of.
Yeah, I think it's just low. I mean, I usually don't like going to court TV because court TV has like too much graphics all over the place. All right, let's try.
Importantly, going to articulate.
Oh, this is way better. This is better, right? Okay, yeah, way better. All right, let's try this. Sorry, y'all. I think a law and crime is just really low, and usually I can fix that. Okay, so Judge Canoni's talking a lot.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan from the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning,
Okay.
Your Honor. Robert Alessi on behalf of Ms. Reed.
Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed.
Okay, it was a browser
All right,
issue. It wasn't a
so,
me issue.
Last week, upon hearing of a previously undisclosed relationship, perhaps, between defense counsel and the ARCA witnesses, I took a recess here. We suspended. I had heard about
She okay?
email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year roughly 2 months before the ARCA witnesses testified. There's another email that was 2 days before the trial and after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions.
Wait, does she always talk like this? I feel like she's just running out of breath. I don't I don't know. Did she always talk like this and I just had it sped up and I didn't really realize?
And after the trial,
Maybe she ran a court today.
there's an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep.
Hey, Salsa.
Clearly, the ARCA witnesses were expecting to get paid. So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people.
And I think that's good. I would have wanted them to answer right away because, I like getting people off their toes. But I'm sure the defense could have just been like, hey, Your Honor, this is like a serious accusation. Could we just do a continued, could we just continue it next week? And she'd be like, yeah, sure. Let's do that. Oh, man. And then also, the other question that I had in my head was, so did ARCA just testify for free? Why would they want to do that? They weren't being paid for the feds, and it seems like the defense wasn't allowed to pay for them. So why would they just want to come and testify for free, right?
And that it made sense to give you some time to do all of that because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti where I raised my skepticism about defense counsel in a murder case calling not one, but potentially 3 witnesses that you never talked to.
Yep.
I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence.
Hi, Moondog. Hi, Salsa.
And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context.
Wait, is she going to go more into what it is that she remembered differently than what the Commonwealth reported last week? I want to know that because that was probably during the trial stuff during trial number 1. But I guess that's not the issue. The issue is what happened at the beginning of this month, February 6th, when they're in sidebar or sidebar. Hi,
So
Edward.
we will mark that as an exhibit.
Sidebar.
And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am going to be responding on behalf of defense counsel
Okay.
to all
What? They're going to make Mr. Alessi do it? Mr. Alessi wasn't even there during trial number 1. Okay.
of your concerns.
I like him,
I
though.
have a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with Your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed to you, or bring it up?
A court officer will take it for you.
Can I have it too, please? Mr. Alessi, can I get a copy?
You're welcome.
Oh, they're so organized. We love organized people.
Thank you.
Here's another notebook to follow along. And with that, Your Honor, I'm going to go to the podium and make my presentation.
Okay.
See, he calls it the podium. I know some people get really annoyed when you call it the podium.
You know what, actually, I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you, Your Honor.
This is why we start late. Look at this. We could just fast forward right through it. And now we're back, y'all. It's actually a good thing that we watch the court TV feed instead, because Law and Crime, I don't know. Oh, maybe I just didn't have it right at the right location or something. Yeah, it's probably a me thing. Just kidding. I don't want to shit on Law and Crime. I love Law and Crime.
All right, so I apologize if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with what's in the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Table of contents.
Yes.
Okay, good.
Oh my God, this is so exciting. I want to know what happened.
May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components. And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to start with the notebook that I handed to Your Honor and to Mr. Brennan this morning. The notebook is purposefully in chronological order. The notebook is in chronological order because I believe the best explication of the facts and what those facts mean come from a proper chronological presentation of the facts. I also believe that the chronology is going to address many, if not all, of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address those concerns. But my intention, Your Honor, is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper determination. That is my genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor, you can feel free to interrupt, pressure test me on anything I'm going to say. I would welcome it, but I believe if I can get through the chronology, my hope is that the facts will speak for themselves, but that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing.
I like the way he presents things. It's like, here's what I'm not going to do, Here's what I'm going to do. Here's what I'm hoping to achieve. And try not to interrupt me, but I'm happy to answer your questions. But let me get through the chronological shit first. I like the way he does things.
On February 18th. And I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript.
Yes.
There are 9 pages that I'm going to go through, Your Honor, and because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be methodically.
All right, so are you addressing this in chronological order as well, right? So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them, but I'll hear you going up to that point. So what pages are those?
And you're referring, Your Honor, to the February 18th transcript?
Yes,
Yes,
your number
I will tell you exact
8.
pages that I'm going to refer to. And Your Honor, this is tab 8,
Right.
the notebook. And specific pages that I'm going to reference start on page 53.
Okay.
And those are 9 pages that proceed all the way to, really, the substance ends on page 62.
Okay.
And I appreciate that Your Honor wants to take a look at them, because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So am I understanding, Your Honor, that you would like me to
You
suspend my
can,
brief or keep going?
no, you can keep
Okay.
going, and we'll stop so I can read whatever I think I need to read
Sure.
at certain points, but we should.
Oh, I think the issue with the audio earlier is because I don't think there's a microphone right here. I think the audio that's picking them up are these microphones over here. Can we just put the microphone over here? Unless there's like a hidden microphone underneath there or something. But like, yo, grab the microphone.
It'd be good to at least start.
Thank you.
And can I just ask, when was this put together?
Started about a day and a half ago and was completed this morning.
Okay.
All right. Holy shit.
Go right ahead, Mr. Lessie.
Thank you, Your Honor.
Good job.
So I start with tab 1, which is the March 22nd, or excuse me, go to the bottom, please, the March 20, 2024 email. And this is an email between Mr. Jackson and Mr. Wolf. It was sent from Mr. Jackson to Mr. Wolf. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts. But I want to go backwards to start in terms of something that is well known. And that is the federal investigation and the products of that federal investigation produced the ARCA report. And that was in February of 2024. So what preceded this communication was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the ARCA report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the documents in March of 2024. And as Your Honor will recall, the trial 1 started in April of 2024. So it was pretty close to when that trial started. And I know Your Honor knows from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report that the vehicle, and this is important, Your Honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Ms. Reed made contact at all with the decedent, and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth and to the defense.
So I think he's trying to say the defense had no influence on the report whatsoever. It was already done, and then they received it in March.
Next step, important also.
Important.
Any party, the Commonwealth or defense, had access to ARCA. They had the opportunity to contact ARCA. There were restrictions that I'm going to get to on that contact. But either party had the opportunity to contact them. Now, only the Commonwealth knows why they didn't take that opportunity. It may be because of the findings. It may be for other reasons. I don't know. But I understand the facts to be that the Commonwealth didn't make contact with the ARCA experts. The defense surely did. So that is the background. That is the information that we have. And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed. Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as Your Honor also knows, the rules of the road with regard to the ARCA expert were not set by this court. They were set by the U.S. Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court.
Right.
So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law, meaning you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way. And when there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings
How's the audio for you guys? Is it good or is it too loud? How are we feeling about the audio?
me with that important background to tab 1. And to repeat, the communications start with a report from the ARCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first communication in tab 1. It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero input into the report and therefore had zero input into the findings. And in fairness to the Commonwealth, nor did the Commonwealth. So with that, we come to the emails on
My mouth breathing is pretty loud. I don't know. Maybe might be Judge Cannoni back there or something.
tab 1. March 20.
You might be having a panic attack
Mr.
right now.
Jackson to Mr. Wolf. Please note that there is no CC to Mr. Yannetti. Why is that important?
Okay.
When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important.
Is it because Yannetti was the one who replied to the judge during the trial? Because I remember it was June 10 was when Yannetti replied to the judge in regards to not making any contact with, I forgot what the exact quote was. I have it here somewhere. But I remember Yannetti made that communication, but I think Jackson was in the court. He says, hired by the federal government, provided the report pursuant to the TUI request, could not prep with the defense, only coordination and outline. That's what Yannetti said. Judge says we need to voir dire, but I think Jackson was still in the courtroom though.
Important. So we have a communication, and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your Dr. Rentschler's and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying. That was the hope.
Was the federal protective order that was referenced by Mr. Yannetti that said it was specifically outlined and ruled that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question directly.
I'd like you to answer my question.
Yeah, I wanted to say it. I'm going to answer it directly.
Okay.
What Mr. Yannetti articulated as the rule of the road, not prep, was not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations with the ARCA experts, okay? That was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation. But I do not know the answer.
All right, go ahead.
And it's an important question, and it's an important answer, I understand.
Wait, what? I feel like he should know by now. Or does he just want to get to it when he gets to it? I was a little confused by how he answered that just now. Hi, Shaniqua. How are you doing today? It's throwing me off because I don't like hearing my last name. Hello, Mr. Jackson, Miss Jackson. All I hear is my dad. Hello, how's it going?
But I'm going to give you information that's going to indirectly answer that question, but I'm going to get you a direct answer as well.
Is she a chain smoker? I don't think so.
So you see that there's an attempt to iron out the logistics for your preparation in the trial.
It would be very hard to be a judge and be a smoker because I feel like you don't get breaks that often. You get like what? You come in the morning, you get a morning recess, you get a lunch, and then like an afternoon recess. Could that be enough? I guess it could be, but I don't know. I feel like it'd be like too like antsy.
Then we get to the email up above, and that is merely 2 days later. Again, Mr. Yannetti is not copied on the email, and my understanding is Mr. Yannetti is not knowledgeable about these communications. So the email reads, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it." Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement and if they were going to be testifying, subject to whatever constraint.
Jesus. Why is the subtitle so off? I'm sorry, I just realized it's like late. What's going on with today? Is this subtitle off? Let me see.
Of the facts. I also believe that
Oh yeah, the subtitles are off. Why?
this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly inchoate at that point. Why would Mr. Wolf be saying, until we receive additional information from their office, the U.S. Attorney, regarding our involvement? This is just talking about mere involvement. So what happens is I call this the pause email, and it's regarding engagement.
Okay.
So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if ARCA's willing, if they're ready, if they're able, etc. And then we have the pause.
Oh, the patches.
next-
True.
Tab is tab 2, which is the very important June 10, 2024 excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript is also exceedingly important. What happened between that? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yannetti gave the opening argument for the trial. Do you recall, Your Honor, that Mr. Yannetti never mentioned the ARCA experts in his opening?
I did not review the openings. I reviewed only, for the non-evidentiary transcripts I reviewed, was only Mr. Jackson's closing argument.
Certainly fair enough, Your Honor. Why do I underscore this point? Mr. Yannetti did not even mention the ARCA experts because the defense didn't even know if they would be testifying. The two most powerful witnesses in support of the
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can.
April
I
29.
can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th. And so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying. If there was an agreement that they would testify, that would have been in the opening. But the uncertainty about it is the reason why it wasn't in the opening. We didn't know what would be happening, so that pause continued through the opening. That, to me, is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript.
Okay, with Mr. Yannetti.
And as I said, I am going to hit head on these areas. I start with, Your Honor, something that's not in the excerpts, but Your Honor may recall that there were a lot of Rule 14 discussions. And Your Honor and Mr. Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. They said, we've given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy. Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire. And that the ARCA witnesses were going to have to come up from Pennsylvania and they were going to need to sit for a voir dire. I will get to the significance of that, but that's what started, is the predicate for the discussion I'm now going to focus on. It starts on, this is tab 2, page 2812. Line 5, the court. Now, regarding the 3 experts from ARCA, so I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided? You're referring to the defense, of course. Mr. Yannetti, Your Honor, we've provided everything that we know. We mentioned to this court at sidebar these experts did not arise from us finding them. The court, I understand that. Mr. Yannetti, these experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court. And it's important not to stop there with what Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important. The court. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question
That's exactly what I said.
Pardon me?
That's exactly what I said.
Yes, and I want to key in on you've never spoken, right, to and putting them on the stand. Now, no one ever said from the defense they never spoke to them, but that was what Your Honor was concluding from what was stated. So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if there was sometimes two people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says, that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background. And I've got definitions
Oh, I have outline here. Maybe it was background.
of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So I want to continue. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides had. And I know the immediate response might be there, it might be at this point, wait a minute, you haven't had time to interview, et cetera, but what has been the communication up to that point? It's been the first communication from Mr. Jackson, mentioned in the March 20 email, and then the pause email. That statement of Mr. Yannetti, as best as I can gather, is 100% accurate. It is not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point. The statement of Mr. Yannetti is 100% accurate. Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor, and this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for a voir dire that can testify yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. So the defense is not fighting with bringing them in for a voir dire. That's, Mr. Yannetti says, that is fine. So I said I'm not going to conflate issues, but there's overlap of issues. So here you have a Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire. The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get to how that interacts with the Model Code 3.3A1 in a moment. So we have then the voir dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page?
It's tab 3, and it's the June 18, 2024 voir dire examination of Dr. Wolf. And before I get to the specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I am making. We all know voir dire is the opportunity for anybody to ask virtually any question they want of the witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. In recalling Your Honor's concerns, right, I don't know who even is opining on what. I went back and looked at that, Your Honor. Pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense's making. We got what was sent in cement, the reports. That's the way they came. We didn't create a report that blended experts as to what they were going to say. That's what got dropped in our lab. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others,
Mr.
because
Lally?
I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement, unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism, because the Commonwealth had the opportunity to interact with the ARCA experts. They had the opportunity to call them as witnesses. And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell. That was the opportunity. They had a Dr. Russell opportunity with Dr. Wolf.
Okay.
What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight in Monday morning quarterbacking would have asked them. But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask those questions. Had they asked those questions, they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But I want to get to the prejudice, and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages. Not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolf the questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work. Mm-hmm. And then it goes on where, for instance, let's say a pedestrian is coming down to the roadway at night. There's also going to be, that I'm going to get to in chronological order, Dr. Wolf on direct talking about nighttime visibility work.
So I mentioned this in my video because remember when the defense and Dr. Wolf there was like these notes, and then like in the margins there were notes with the defense communicating with, I guess, Dr. Wolf, and there was a mention that something about pedestrian hits commonly happen at nighttime, and Dr. Wolf is like, should I not mention that? You know, because I guess that wouldn't be good for the defense. I was like, oh, I feel like this was already mentioned though when he did his voir dire and his testimony, and he did mention it during both of those. So I guess maybe the defense is trying to say that, well, Mr. Lally could have asked about that in his line of questioning. He could have been like, oh, so you do a lot of nighttime visibility work? Okay, so like how often do you see pedestrian crashes during the nighttime? Do you see it more often in the nighttime or the daytime? I wonder if that's where he's going.
Etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility in pedestrians affirmatively in voir dire. So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask, and as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email, but it's important who it's from and who it's to and who's not on. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yannetti on this email.
Okay.
And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm. Where
You know what? Actually, maybe it is good that they had Mr. Alessi come up here and explain everything. I mean, not only is he really good at giving the outline and making the expectations clear and all that, and he's really easy to follow, but maybe if it was Jackson or Yannetti going up to explain themselves, maybe it would make them look too defensive. But having Mr. Yannetti, who wasn't involved at that time, explain everything, that could be a better for optics, actually.
you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face, and one of it is you can always tell what goes along with the email. So this is attachment Wolf Qual's document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document, not Mr. Jackson.
No, I am well aware of that.
Okay, so he prepares it, he sends it along to Mr. Jackson, and it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony in that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor. The next tab, and of course, it has the D&T of Dr. Wolf, his experience in testifying in court, et cetera, et cetera.
What did he say D&T was again? Direct and testimony? Is that what he said? D is direct?
I will indicate, Your Honor, that the information in terms of quals, etc., all of that, to me would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, inquiry, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Wolf to Alan Jackson. Subject, Wolf Direct, attachments, Wolf Direct. So it's clear, and then if you turn the page, that is the
June 23rd. Okay.
at 2:59 p.m. from Daniel Wolf to Alan Jackson. Subject, Wolf Direct, attachments, Wolf Direct. So it's clear, and then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of ARCA, the frozen in concrete report of ARCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom, is that Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate that Your Honor
Hi,
has,
Shanzo.
Seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report
Hey, Amanda.
that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the Rule 14, and we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered. I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, et cetera, and I'm going to get to it, and I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolf who prepared it and sent it to Mr. Jackson. Now I want to get to the timing, because I think this is very important for the Rule 14 issue. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. So the other important
I missed that.
I think that person would have to have quite a fanciful imagination. I heard an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it. I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. So the other important point to underscore is that this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson.
Okay.
So if someone is to say that, and I'm not inferring, Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, et cetera, et cetera. What happened the next day, one day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolf, under what parameters, under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it, came to my mind. We know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this and when Dr. Wolf is on the stand, because that's really the prejudice time period or potential, if you will, that occurred.
So this is a document that was not prepared by Karen Reed's attorney. It was prepared by Dr. Wolf, the ARCA expert. So I'm assuming this is the document that they should have also sent to the Commonwealth, but they didn't. But he's saying that, like, oh, we got it on Sunday, like it was like kind of late, and then his testimony's the next day. Probably just didn't think of it. They probably just forgot.
Not even to bring in the voir dire, that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think perfectly tailored to the situation, to basically say, I don't, as the court, understand, these folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of it. We got the report, and all we had is emails in March, right, that are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is, what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered? We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolf. I mentioned, Your Honor, about the nighttime visibility issue, because much was made of that in the hearing 1 week ago. If Your Honor could please turn to page 3665, starting at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up? Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, a great deal of my work is in the field of lighting and visibility, so there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. Elicited, discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please. Line 9. This is, again, by Mr. Jackson. At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Ms. Little? No. That's correct. Mr. Yannetti? No. Fact. As a matter of fact, you had never heard of this case. That's correct. Page 3670. Line 10. Question. When did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer correct. Question. And that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this.
He talks so fast that sometimes I'm like, wait, do I have this sped up? And I'm like, no, this is normal speed. I love the way he talks.
Correct. Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct. And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused with a March 22nd email, and they never were re-engaged. They were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement. To the best.
Yeah, so I guess, did they just do it for free or for free maybe? It's like 2 ARCA experts. There's like, hey, we'll just do it for free. Let's just do it. I don't know.
To my knowledge,
Get our
in
names
my
out there?
review of all these facts and discussions with counsel. So then the next, that's correct. Question. As a matter of fact, I've never asked you specific
What about travel expenses? Who pays for that? Hotel, food, and all that?
questions about your testing before today. That's correct. Mr. Wolf sent in questions that he proposed Mr. Jackson asked, but that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolf sending them in. And, Your Honor, I'm going to speculate if I could, and I'm not going to do this often in my presentation, but I do know a fact, and I do know, and a fact I know secondhand. If we put ourselves in Dr. Wolf's position,
Hey, Mandork.
for attorneys, imagine him.
How are we doing today? Hello, hello. They got their expenses paid by the defense, I'm pretty sure. Would that have to be disclosed to the other side? I feel like yes, right?
He's about to sit on the stand in one of the most visible cases in the country. He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having. But he's got to go on the stand with his professional reputation, and he's nervous. He's nervous. So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits, okay?
I will not.
You can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor. And I
If
said
you
it-
know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th, what I think is really important.
Okay.
Because The Commonwealth on the 18th speculated a lot, and I
Okay.
think the only way to fairly...
So let's go back to this, okay? You'll get to February 18th. Do you know for certain that that's what Dr. Wolf was thinking?
Here, I will tell you the basis of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was anxious about the fact that he had to get on the stand without having the typical level of preparation and knowing. That is Mr. Jackson's sense of Dr. Wolf's situation at the time the direct was sent. So, can I say for certain? No. Can even Mr. Jackson say for certain? No. That's the sense, though, that was extant at that particular time.
Okay?
So we then go down to the next question.
I don't remember anyone mentioning the expenses thing, so I don't think it was. I don't remember Brennan, or I don't remember. Well, the defense even have a chance to respond last week, but I don't remember Brennan mentioning anything about the expenses or anything. Also, I don't remember Lolly asking any of the ARCA experts, like, so you're just here to testify, what, for free? Were your expenses paid for?
But I want to come back to
How's
that
it going,
question on 12.
Mandark?
As a matter of fact, I've never asked you specific questions you're testing before. That is correct. That's an accurate statement, Your Honor. That's an accurate statement. 15, your work product, the report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding, yes. And you were equally available to both sides in terms of them reaching out, correct? Yes, and I called you ultimately after receiving your report and asked if you join us in...
Yeah, that was when the state was like, oh, there was like a bill for $23,000 something. So I think the state was trying to say like, oh, is that what you paid for the defense to testify for you, or what is this $23,000? I don't think he knew what the $23,000 was.
Testify, correct? That's correct. Why do I point that out? Because it's not only my sense when I said earlier that and I don't think this is disputed, the Commonwealth had...
The other speculation was maybe it was just a bill that was attached. Maybe that was like how much the feds paid the ARCA experts. Because $23,000 for expenses, that's a lot. Especially it was only, well, okay, fine. It was for voir dire. They came in for voir dire, and then they had to come again a couple days later for the actual testimony. Like $24,000? Fly them in, hotel, food, like that's not $24,000. That's what I was thinking. Like maybe that's just like but then I don't know why why would Dr. Wolf send the bill to the defense? Like, hey, this is what the feds paid us. Unless that was before they had the pause period where they weren't allowed to engage further. Because maybe they were hoping to get hired by the defense, and then Dr. Wolf was told by the feds, oh, hey, like they can't hire you. We still have our own active investigation going on.
Equal opportunity to contact ARCA. That was Dr. Wolf's sense as well.
Unless they were flying from like Japan or something, first class from Japan. Had the party bus come pick you up.
So that is
Got the Gordon Ramsay personal chef.
direct testimony of Dr. Wolf. And I want to just speak to the findings because on
Hey,
page
Sparky.
3676 to 3677, because the findings never changed one iota from the report ARCA issued in February to Dr. Wolf's testimony. There's been a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolf before he testified. And the key emphasis, and I think should be the key concern of everyone, certainly was the concern of the U.S. Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the U.S. Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings, and you're going to deal with the findings that they have. So what were those findings? Bottom of 3676.
Pickleball?
line
Yes.
25, did you perform an accident reconstruction? Specifically,
It was very
focused
dusty.
on determining
It was
whether
horrible.
or not damage to the Lexus was consistent with hitting Mr. O'Keefe. Answer, yes. I think that's a fair characterization. And reversing that, was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle? So it's important to know, in terms of, whatever the interactions were and whatever the effect of the interactions were,
Hey, Gwen.
is that the findings always stayed the same. And what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024. So now we go to, and of course, the findings of ARCA being that the vehicle did not come into Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe
Oh, how long you been playing for? Hi there, hope your day is good. Yeah, Gwen, it's been a while. How have you been?
incurred were not the result of an interaction with a motor vehicle. So now we go, Your Honor, to the tab 7, which is the invoice.
I remember, okay, this was the ARCA findings. They did like 3 experiments. One was, could John O'Keefe have thrown the cocktail glass hard enough to break the taillight? The answer was no. The second one was, could the car backed up into the cocktail glass that John O'Keefe was holding and cause that to break? And they said no. And then I think the third one was, could the car have backed up and hit the back of the head of John O'Keefe's head and break the taillight? I think that's what the 3 main experiments were.
I am going to be very precise and point out some items, hopefully for an efficacious purpose.
You've been precise this entire time, Mr.
It
Alessi.
says at the top, ARCA invoice date, July 12, 2024. Of course, by then the trial is over. Your Honor correctly noted in your prefatory statements about these line items that are in it. We don't run from one word or line in this invoice.
Oh, since November? How do you like it? It's fun.
But it's important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March, and it wasn't even any discussion about particulars, etc. It was just the defense feeling that they were going to be calling these witnesses, and there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARCA was going to be compensated by the defense. It would have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows, I was not a participant in the first trial. I'm not speaking with firsthand knowledge on any of this, but I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice. Came out of the blue.
Wait, what? Like ARCA built them after the fact? Yeah, because I was like, why would ARCA want to go up there, do the voir dire, and then do the testimony for free? The only way I can think of is like, oh, maybe they wanted to do it for free because it gets their name out there. This trial has a lot of eyes. I don't know. That's possible. So he's trying to say that, oh, ARCA just sent us the invoice out of the blue. Like we weren't expecting to pay them. Wait, there was no discussion of compensation whatsoever? That should have been like the number one thing. Like, hey, like, what's our compensation going to be? Like, what's up with this? You know, I'm not going to go there and testify for free. Yay, you're going to put me on the TV while you do some chores. Oh my goodness. I had a mountain of laundry to do. It took me like almost like an hour and a half to fold the fucking laundry. It was so much. You had some health issues, but you're better now. Oh, I'm glad to hear that you're better. Tam also, it's nice to be back on the good side of that biz too. I'm glad you guys are feeling better. Yeah, health issues suck. Oh gosh.
It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount.
I mean, and probably Karen Reed. Karen was like, what the fuck was it? It was right. Was it the 24 grand? Jesus. I mean, did the defense really expect him to testify for free? There was no discussion of compensation?
So what happened? And this is, Your Honor, objective. These are recollections. Information. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it?
Oh.
I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation? Because, as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay.
Okay.
Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything? There would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, the date of the invoice is July 12th.
Now, does that have to be disclosed to the Commonwealth? Because later on, remember how this is in July, right? I think the Commonwealth said they receive emails, like just like emails, shit, attachments, stuff with no dates from, initially said the feds, but then he amended to the defense. And that was like this year, right? Was it this year? Yeah, I think it was like this year. What's this year?
And I think I can get you the exact dates here.
What the fuck?
Mr. Jackson's firm, not Mr. Jackson, but a staff member, and I want to be careful of attorney-client communication, so I'm not going to talk about the subject, but communicated to Ms. Reed that this invoice had come in. And I believe that communication was toward the end of July, maybe I'm going to roughly estimate the 24th.
Can we get Dr. Wolf to come in here? Can we hear from Dr. Wolf?
And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that? Within a week, within that July 24th date?
Get you an exact answer?
I would like that.
Sure.
Deitch, D-E-I.
I'm going to attempt to get an exact. If I can, I think I can get a good approximation.
Mr. Deitch. You guys are curious how Deitch is spelled? It's D-E-I-T-C-H. You're welcome.
Your Honor, I understand a check was sent to ARCA on July 25th.
Thank you.
You're welcome. So there's no doubt the invoice was paid. But the story is not solely about was the invoice paid. The important part of the story, what the facts, is it came out of the blue. And I don't expect anybody to take my characterization 100%, but that's my full understanding. But the call to repeat to Mr. Deitch is, to me, the corroboration of that very point. And it's an important one. It's an important question. and it's important, very important question, but it's an important fact point as well that call was made. So in terms of the next tab, which I've been alluding to during
Okay, so this is the one I said I needed to take a recess to read
I was just
that.
going to say the same thing.
All right,
This
so-
is now that point.
All right,
Oh,
why don't we take a 15-minute
She takes a recess. Ugh. Okay, she lied. She didn't even take a 15-minute recess.
recess?
All rise.
You are muted.
Would be fabulous to see Dr. Wolf again. Dr. Wolf. Oh, it's the fan.
Stand in recess.
Paging Dr. Wolf. Paging Dr. Wolf. Paging Dr. Wolf. You're needed here. It's an emergency. We gotta know what the fuck went on. Okay, so, Jesus. Well, you know, Mr. Alessi, I don't remember Mr. Yennedy's opening statement. But I'm starting to think they might have to get Mr. Alessi to do the opening statement or the closing. Or both. Because, man, so organized. Easy to follow. I love it. I love the timeline. I love, like, the way he sets expectations. And I think Mr. Alessi knows that this judge is a little bit... She could be a little bit sharp sometimes.
And as I go...
Oh, he's back. He does a really good job at acknowledging the judge's frustrations. And honestly, like, this man, he doesn't let his ego get in the way. Doesn't let his ego get in the way. He's like, oh, okay, Your Honor, you know what? You're completely right. Man, you are just... The one thing that I learned about being in this court is that you are just so on top of everything. So, what was I saying? Okay, anyways, Mr. Alessi, cool guy. We're back from the break.
Proceed. Court is back in session.
May I
Jack's face of death. Alessi has a good grasp on this case. He has every detail in his head. Alessi's indiscriminate shutting.
proceed back to the podium, Your Honor?
Please.
Wait, maybe he saw the judge was falling asleep a little bit. So he's like, hey, wake up over there.
Remain seated.
You can go back.
All right, we're pretty much almost caught up. All right, Alessi is
May I
back.
continue, Your Honor?
Please.
Thank you.
I think Your Honor was in chambers. You know, she was looking at the invoices sent, looking at all the timelines and stuff like that.
So, Your Honor, to blend and quickly summarize what we've gone through, I'm using the table of contents of the notebook. We've spoken about the March 20 and March 22nd email from Mr. Wolf to Mr. Jackson. We've talked about June 10th and statements of counsel. We've
Yep.
talked about comments of Your Honor. June 18th, we've talked about briefly the voir dire of Dr. Wolf and the opportunities the parties had there. We talked about the June 22nd and June 23rd's emails from Dr. Wolf to Mr. Jackson and the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolf, July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now, with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do it, Your Honor.
I like how he does things. Okay, I like expectations. But you know, she's a lot smarter than me. She doesn't need it. She doesn't need expectations laid out for her.
Now to the
God.
transcript. And as
Right, yeah,
I
no
go
more
through,
expectations.
I start on page 53,
Okay?
line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive the defendant of ARCA as a witness was made 5 times. I counted them, and we'll go through each one and number them.
Okay, so this is last week's hearing.
Or deprive the defense of an ARCA expert in this case. Very important, because from my perspective, what was put in the firing line on February 18th was the ARCA experts, albeit indirectly. So now we go to page 54, and this is going to be, in some points, a line by line, because the words matter. Line 5, and this is again is Attorney Brennan. Well, what the government worries about.
I'm sorry, guys. I screwed up. During the break, I should have went to use the bathroom. I'm going to use the bathroom really quick. Get up, stretch, use the bathroom too. We'll be back in, I don't know, 30 seconds. You got 30 seconds. That's it. That's all you got. I lied. That wasn't 30 seconds. Hi, Aaron. How are you doing today? Aaron, did you watch last week's hearing with the basically the big cliffhanger? It felt like TV to me. You know, one of those things where like you're watching TV and then it just like ends and you're like, no, I want more. I want to know what happened. All right. So far we have Mr. Alessi, who is going to explain to the judge what happened with the ARCA defense. Now, Mr. Alessi wasn't the attorney hired during that time, but now that I see Mr. Alessi in action, I'm like, I think he was a good guy for this. Also, if we had Yannetti or we had Jackson going up and explaining their actions, it could make it look like they're being too defensive. So it's good to have someone who wasn't hired on the team to explain what went down. Right now, Alessi is saying that, well, once I give you the timeline and everything, it all makes sense. And so he gave us a timeline. Things were making sense. However, we got to the part about the invoice. Alessi says, out of the blue, an invoice was sent to them after the trial had ended. That was in July. And so the defense, I guess they didn't expect ARCA to bill them, which I have a hard time believing. Because like, why would ARCA show up for voir dire? Why would they testify for free? That doesn't make sense. Now, they weren't supposed to pay ARCA, because if they did pay ARCA, then they would have to disclose that to the Commonwealth. But they said out of the blue, they just got an invoice and they were worried. So the defense called the Attorney General's office and the U.S. Attorney's office. And then they're like, yeah, I guess just pay it. Now, whether or not we believe the invoice came out of the blue, we gotta keep listening. I don't know what the judge is going to think. Unless he should have put on the blonde wig. No, we don't need him in a blonde wig. Yeah, we like his hair just fine, just like this, okay? We don't need Judge Cannoni's blonde hair in here.
Is that there is
Hi,
other
Miss Mentat.
things
How are you
that are
doing today?
relevant, like compensation.
Wait, what happened to the audio? Oh, is this? Hold on a second. Oops. Did my earbuds break again? Okay, so that's where we're at right now. The invoice was sent out of the blue. Out of the blue. Defense paid it. And then I guess at some point the defense sent like a bunch of shit to the state, and the state was like, what the hell is all this?
Promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about and can't ask about. I'm going to stop there. That they don't know about? Really? don't know about the ARCA experts? February 12th report? A voir dire?
How are you?
Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity. Next statement, that there's some bias or favoritism that the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it bias, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that that expert is biased. But this expert was not engendered by the defense.
But see, Brennan was going off the little information that he had. He had like these emails. He had some that like didn't have dates, or like invoices and stuff like that that didn't have dates. So his natural assumption was, oh, okay, there's some really weird shit happening that the defense is paying these experts and they didn't disclose it to us. And they tried to say that, oh, the only purpose of them meeting with the only conversation they had with ARCA so far was just for the purpose of coordinating their testimony and then background. And so I could see why Brennan came to the conclusion of like, oh, wait, actually a lot more happened. And did the defense just not disclose this to us? Now, maybe Brennan didn't think it was that serious, because Brennan could have maybe moved for having one of the attorneys not be Karen Reed's defense attorney anymore. Instead, he was just like, okay, well, let's just not have the ARCA expert testify. Because I felt like Brennan could have asked for more of a severe repercussion, but he didn't. He was just like, okay, let's just not have ARCA testify, which is bad. It's bad. But what's worse, not having ARCA testify or removing a whole ass fucking attorney and then accusing them of like lying and misrepresentation and stuff like that?
It was engendered by the U.S. Attorney's Office in their federal investigation. Next, on line 12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now, I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense.
Hey, Brian, how are you doing today? So I'm going to rewind it a little bit. Just give me a second. Okay.
It was on February 12th of 2025. Now, I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense, which was completely false. So this is a buildup. It's all in.
And what was the date again that the defense provided it?
February 12th?
The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud here. I'm going to answer it. I think it was February 12th that it was provided of 2025, but it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery, et cetera, et cetera. So
How are you, Brian?
I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the
I think what happened was because when Brennan was talking to the judge last week, Brennan said that it was another attorney, I think, Attorney McLaughlin, that was writing back and forth, got new materials and stuff like that. I think what happened was maybe Attorney McLaughlin either told Hank the wrong information, which I don't think. I think what happened probably, maybe he misunderstood what she said. And he like misrepresented, but I don't think he would purposely misrepresent it. Like, oh yeah, it was the federal government who had to provide this because the defense wouldn't, because that wouldn't make sense. Why lie when later on you could just be caught in that lie later on? So I think what happened was Attorney McLaughlin handled it, and then maybe he just misunderstood. And then after the recess happened, either Attorney McLaughlin was like, oh, you know what, Mr. Brennan, what you said up there was completely wrong, or I misunderstood. I don't know. Because I feel like if Attorney McLaughlin was in the courtroom, couldn't she just interrupted Hank Brennan? Maybe she wasn't in a courtroom. But I think there was just a major misunderstanding. And then after the break, he was probably told that, like, oh, actually, it was the defense that provided this, not the feds. And then that's why he went up there and corrected himself.
Defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false.
Okay. But what I was going back to, yes, if it was the federal government that provided the information to Hank Brennan, it does make his case look even stronger, or it makes it look bad for the defense, right? But I don't know if it matters who ended up providing it ultimately in terms of if you're just looking at the substance of it, which would have been, did the defense pay the invoice? Did they expect to pay the invoice? Did they not expect to pay the invoice? Did they provide the invoice over to the Commonwealth? So I think the defense did a good job addressing all the other stuff, like the timeline of how the engagement went down between the defense team and then Dr. Wolf and the emails and the chronological orders and stuff like that. But I guess the issue right now is maybe the invoice. I think that's where we're at.
Let's go through each word because it gets really important. When there are claims made that the defense has not turned over something and there are words used like ambush and duping, it's important to understand and get behind those verbs as to what the facts are. So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voir dire occurred? It's not the ARCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCA. And why do I keep repeating this? Because my conclusion is going to be ARCA should be unscathed. ARCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had for 5 days the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance. And believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before. But his comment here is I've read the transcripts, and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on, and on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup, which is at the bottom of page 55. Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about interactions with defense counsel. That's what was talked about above. So I called the federal government. There's no statement here. There's much more to the story. And I've got the discovery that the defense provided that told the complete story. So there was, and I'll tell you, my impression from what is stated here is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information, so they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. It's another statement so ARCA could testify.
Oh, look at the highlights
I
here.
was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day.
That's like my favorite Brennan quote so far.
So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I want to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but a qualifier, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCA, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds, when he really got it from the defense? There's email correspondence between the defense, but not only the defense and the federal government, but the ARCA witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolf, who's one of these ARCA witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's incorrect. Then we proceed down to page 57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements, or payment. They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection. There was no promise, rewards, or inducements or payments before all of those documents that the Commonwealth is referring to here. That didn't come until the invoice came in July. And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay it. So next, on page 57, line 11, he reads, response, hi, Alan. Subsequent to our conversation on Wednesday, this is, I think he's reading from the March 22nd, but one of the the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates, so it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, I am going to...
What date was that?
Your Honor was asking aspects of this second, but one of the... Response. Hi, Alan. Subsequent to our conversation on Wednesday, this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates, so it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about...
Like, did the defense not provide some stuff to the state with dates and stuff like that? Or did the state just misinterpret some things? Or... Because I know there was probably an attachment that didn't have a date. It was like the one of the notes and had like the notes in the margins and stuff like that. Oh, sorry, it was an outline and there was like notes in the margin. That didn't have dates. And I was thinking maybe because it's just an attachment. But I think there was some other stuff that Brennan said that didn't have dates or something. So he was like, it seemed like he was a little confused.
About dates. But this is a very
Hey, Nicole.
interesting paragraph. Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, I am going to please ask you to turn back to tab 1 of my notebook, because this was a purported quote of...
But we don't, when was this sent though? The conversation he thinks was on March 22nd, but when was this email sent? Was this last year, I guess? I'm assuming it's last year? Because he's talking about March 22nd. March 22nd was that when Jackson and Wolf were emailing each other? I'm assuming it's 2024?
The March 22nd email.
Oh, are they trying to figure out when this was sent? Because they don't know?
That's really not close to what the email says. It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate and that Mr. Brennan accurately, because I'm going to give Attorney Brennan the benefit of the doubt, because I can tell you that I've had my statements in court not completely correctly transcribed by a court reporter, and unfortunately sometimes it's been on some key things. I don't think this is key at all.
That's
But
nice of you.
I just note it, but it says, Mr. Brennan goes on, now it's the opinion that troubles me. It's relationship, and the Commonwealth should have an even playing field. That's number 4 of the time he's not having any trouble with the ARCA experts. Saturday, June 22nd, Daniel Wolf wrote, Alan, I spent some time this morning putting together a brief outline of my qualifications, blah, blah, and this is just a repeat of what we have already heard. Here now comes the important points. Page 58, line 2. Now, this isn't information provided by the defense in reciprocal discovery. Oh my. This isn't information. She's talking about all these emails. This isn't information provided by defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and an insistence, the best I can, to get as much information as I can. It's incorrect statement number 2, and it's an important one. Down below, unfortunately, it gets even more incorrect. Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they've got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. My, that's not a fact, but if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll stop back up at 2.
Okay.
Really?
Right. Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea, and I'm not rushing you, do you have an idea, because we do have the other motions, if we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question. I think I can conclude in 45 minutes because I have to get to the law, the 3.3a. I have to
I'm not rushing you. I just wanted a time frame.
That's my best answer, and I will say this, Your Honor. I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal, believe me.
Okay, so we'll see everybody at 2 o'clock.
You are muted.
What is it, 11 o'clock my time? 2 o'clock. Do we like Alessi? Trying to think. I think I like all the attorneys so far. Jackson could be a little bit, a little bit performative at times. Sometimes Unetti too, but I like them. Alessi I like a lot. Hank Brennan I like as well. Mr. Lawley, not my favorite. Not my favorite, but I like attorneys that they speak very clearly. Sometimes like to, change their tone because, it's easier for me to follow. If someone just talks monotonously like this, it's like it gets boring for me. But, I like a little bit of performative here and there. Just a little bit. But I will say, no one is more performative than our man, Juan Martinez. Jody Arias. That guy was like, I don't know, if I remember correctly, I could have sworn he jumped up and then clacked his 2 heels together or something at some point. That man was wild. And I didn't even watch the entire trial. Yeah, I know people don't like Hank, but I like Hank. And I think the reason why I like him because he's got the defense attorney background. I feel like defense attorneys tend to perform really fucking well. And sometimes you have really good state attorneys as well. Like Creighton Waters, definitely one of my favorites. Definitely up there. What is this music? Is this court TV music? Oh, interesting. Oh, court TV has lunch break music now? Oh, interesting. I'm gonna pause it. I don't know. I'm assuming it's copyright free, but I'm sure. We'll see. Nerdy mafia lawyer persona. Yeah, I could totally see that. Yeah. Got a great accent too. Jesus. All right. So we are going through the timeline. We're going through the timeline and it's a lot. Let's see. Is this all for my notes from today? So I think the timeline does a good job at explaining how everything went down and how, because initially we thought, okay, was the defense and ARCA experts, were they working behind the scenes, coordinating their testimony, and not just coordinating scheduled testimony, but what they were going to say, what was going to be disclosed? Because initially it sounds like the defense did not have time to prep with the ARCA experts at all. But the notes, the emails, a lot of it happened after the voir dire. Where the fuck am I? Yeah, because it seems like the federal investigation released like 3,000 pages, right? And during that, they were able to sift through the defense, and they found that there's an ARCA report in there that would basically exculpate Karen Reed. It showed that Karen Reed's vehicle did not make contact or either with the cocktail glass or John O'Keefe's hand or John O'Keefe's head. I think those were the 3 tests they did. And so defense is like, whoa, this is great. We're going to fucking use this. Now, they weren't able to properly engage with the ARCA experts because the ARCA experts were still the federal investigation experts. And so there was like a federal court order that defense or the state weren't able to hire and like work with these experts at this time, I'm assuming. But these experts could testify at the trial. And so when Jackson and Yannetti were like, hey, we got these like 3 experts. And Judge Beverly Cannone is like, well, so you're telling me you've never really talked to these guys, but you want them to testify as your witnesses in this trial? Like, that's a little risky, but okay, that's what you want to do. And so there was this issue with Rule 14, and Judge Cannone, in order to remedy that, she was like, we'll do a voir dire. So that way, the state gets to ask questions, whatever they want, on the stand from the ARCA witnesses. And that's what they did. Mr. Lawley asked the questions during voir dire. The ARCA witnesses were allowed to testify, and then we had the testimony at the trial. Now, after the voir dire happened, there was an email between Jackson, Karen Reed's defense, and ARCA, essentially talking about testimony a little bit more, where it's like, okay, well, here's my outline, and here are some notes. Here's the thing about, I'm an expert in, I don't remember what the exact phrase was, but it was something about like lighting, nighttime stuff. He sees a lot of pedestrian accidents happen at nighttime. And he says, let me know if you don't want me to mention this. Because obviously that, like initially when I first heard about this, I didn't know why. But then I'm like so stupid. I was like, wait, that's so fucking obvious. Duh. That would help the state, because when was John O'Keefe hit? Or when was he allegedly hit? At night. Car accidents happen at night. So I don't know why I was so slow on that. But anyways, I realized that afterwards when I was driving, and I was like, wow, I feel so fucking stupid. Because I remember I was like asking the chat, I was like, wait, why does it matter whether or not if ARCA believes that most accidents happen at night? Blah, blah, blah. Okay, anyways, I'm digressing a little bit. So going back to between Mr. Jackson and the ARCA expert, they had that, email conversation. Yannetti was not CC'd on that. And then we have the testimony. Testimony happens, and during testimony, I don't remember Lawley asking, just to double check to make sure, like, hey, so you're not being paid by the defense, right? Okay, because it probably would make them look bad. But I guess Lawley could have been like, hey, like, so you're telling me you're just here for free? Your expenses, you're paying for your expenses, your hotel, your food, your flight. You're just coming here for voir dire, and you're just coming here to testify for free? Maybe Lawley could have really hammered in on those questions, but maybe Lawley didn't want to, because if the guy was like, yeah, then maybe that could look really bad. And then like maybe the juries would be like, oh, wait, this guy's here to testify about this for free. Like, okay, like this guy has no skin in the game, literally, like not literally, but he doesn't have any skin in the game. He's doing this because maybe he feels like this woman is innocent. I don't know. Maybe the jury could have went down that thought pattern. And so, well, ARCA goes there, testifies. And then when the trial's over, the defense was like, well, we never paid these guys. We weren't planning on paying these guys. They're here to testify, I guess, for free. So the defense was surprised when they were hit with an invoice. And I'm assuming maybe that's a $23,000 invoice. And Alessi mentioned that, I can't divulge attorney-client privilege, but somebody was really surprised about the bill. And it was probably Karen Reed. Karen was like, yo, what the fuck? This is like $23,000. Damn. And she probably wasn't expecting to pay it because maybe they thought ARCA was going to testify for free. I don't know. That's weird to me. That part, I'm like, I'm surprised there's no discussion about compensation. So I don't know. I think maybe the next serious step, like if Judge Cannone has issues with this portion right here, maybe the next serious step is just have Dr. Wolf come in and testify. Like, hey, Dr. Wolf, come on in. Tell us what happened. You weren't expecting to get paid, really? And you were just going to hit him with the bill afterwards? Like, what happened? Like, why? I don't know. I think we need to hear from Dr. Wolf, maybe. That's where I'm at. I want to hear from Dr. Wolf. And so the defense said that they were very surprised to get this invoice. It was probably the $23,000 invoice, I'm assuming here, because that's an invoice that Hank Brennan said was part of the attachments, but there was no date. I think that's what Brennan said. So Brennan was like, "Oh man, this seems like this was a bill from ARCA to defense for 23 grand. Seems a little bit weird." And now we get to this month, February. Apparently, in February 12th was when the defense, not the feds, provided these email correspondence, some attachment stuff to the state. Now, Mr. Brennan, a couple days later, when he was, presented to the judge, he said that it wasn't the defense that provided this, it was the feds. And then after the recess, he came back, he was like, oh, actually, the defense did provide this. And I think that's because it was Attorney McLaughlin, who was probably working with the state attorney's office, was probably handling this portion of the communication with the feds. I think it was just a misunderstanding. Or maybe Hank did have communications with them and then he just forgot. But then it was like a couple days before. So that's why I think someone else handled it. And then either there was a misunderstanding or maybe she gave him wrong information or something like that. I'm not really quite sure. But I think after the recess, he was obviously corrected and he came back to correct himself. Now, what I want to know is when the defense sent the stuff over to the Commonwealth, did they just not provide dates on some things, or was it just messy, or did Hank Brennan just not do a good job at parsing the information? I don't know, but it seems like there's some things that didn't have dates based on what Alessi was saying recently. But I don't know. That's what I'm waiting for. So we're at a recess right now. The court is getting lunch. And I mean, I think that's pretty much about it. That's what I kind of covered. So yeah, the issue is the surprise invoice. But as Alessi is like, well, this is a new trial, and we're complying with trial number 2. I think he mentioned that the reason why they didn't provide this, I guess, to the Commonwealth of Voir is because at that point, the CW, the Commonwealth, had not issued their certificate of compliance with discovery. So maybe that's why the invoice wasn't given to them until recently. I think that's what it is. But I don't know. I guess Alessi says he has another 45 minutes for his argument. I don't know if the state is going to have a chance to, I mean, I'm assuming they get a chance to reply back to it, right? And then the judge makes her decision. I don't know if the judge is going to make her decision on the bench, though, because the judge tends to say, okay, well, you know what? I'm going to think on this. I'm going to marinate on this, and I'll make my decision in writing in a couple of days. Which I'm like, can you just rule it now? Just make your decision now. I want to know now. Anyways, so he has another 45 minutes for his arguments, and then the judge wants to get on to like other motions. Because remember, this was all supposed to happen last week, but then the judge put a halt to it, and then she wanted to resume today. So if all the arguments don't happen today, I think they said they had 2 days next week where they can continue doing the argument stuff. But man, we're getting kind of close to the trial date. Trial date is April 1st. It is about a little over a month away. Getting super, super close. All right. Well, you know what I'm going to do? I guess I can take a lunch break. I'm not really hungry, though. I guess I can eat cereal. So here's what I'm going to do. I'm just going to leave the stream up, and we'll be back in like 30-ish minutes. I'm trying to think. Is there anything I want to cover, though, while I'm here? I don't think so, because I do have things that I want to do, but they're going to be like longer live streams. I'm trying to think. Is there anything small that we can cover while we're here? Oh, when I mentioned this in the beginning of the stream, the federal investigation has been reportedly concluded. There's been no charges against law enforcement, because initially when the federal investigation was happening, I think a lot of us thought that it was a federal investigation into Karen Reed, whether or not she was involved in John O'Keefe's death. But I started hearing reports within the past month that the federal investigation was actually into law enforcement. So no charges. No one in law enforcement has been charged, but I don't know if that's like they haven't been charged yet, or just there's no charges. Like, we're just done. We're done and that's it. I'm going to go back and watch you on 2X, try to get... I don't know. You might be able to understand me in 2X, but Mr. Alessi talks really fast. Like, I will have Mr. Alessi on 1X, and I'm like, dude, is he at like 1.5 right now? I don't know. I love long streams, me too. I love having streams just to put in the background and stuff like that. Have you heard anything about the Alexi? Oh my gosh, I looked it up. There's been no updates. The last time there's been stuff posted on the case stuff was back in December. I did email the court asking for some documents, but a lot of the stuff was sealed, so I didn't have access to everything. But it just seems like They're still doing the Supreme Court stuff. They're still providing evidence. I did see that there was some involvement with like, I don't know, I think it was like American Association of like Gynecology or something. And there's like ACLU, the American Civils, ACLU, American Civil, what's the L stand for? I know U is Union, Civil Rights Union. What does L stand for? I should know this because of Debbie Heard. Let me look it up real quick. ACLU. Liberties, American Civil Liberties Union. And I should know this too, because I'm reading a book right now where ACLU was brought up multiple times. Thanks, y'all. How's it going, David? How are you doing today? All right, so we'll wait for them to come back. And then let me see if I can just look quick. Karen Reed, federal investigation. I wonder if there's any more information. I don't think they're going to release the details, right? Let's see. Boom. Grave concern remark. No. Investigation is over. Okay, let's read. Karen Reed's federal probe ends. Defense denied key evidence request. The federal investigation into the Karen Reed case is over. No charges were filed against the police. Sources tell. 5 investigates. U.S. Attorney's Office called law enforcement agencies who are being investigated to let them know that the news is expected to be announced as soon as Tuesday. Oh, in open court. In a hearing in Reed's case. Reed has long claimed she is a victim of a cover-up orchestrated by police and prosecutors. How do I get this to go away? Early on Monday, the judge issued some rulings about evidence that must be shared as Reed prepares to go on trial a second time. Reed is 44. She's accused of hitting her boyfriend, John O'Keefe, who is a Boston police officer. There was a mistrial that happened on July 1st. Monday's rulings are in response to several requests from Reed's lawyers for items they consider important evidence for her defense. Defense wanted all the logs showing who handled the surveillance video of Reed's SUV at Canton Police Office. Just as prosecutors must turn over everything they have, but don't have to create logs if they don't already exist. This is all this. I'm gonna look at the federal stuff. 2 sources brief on convos that occurred between U.S. Attorney's Office in Boston and state local law enforcement tells 25 investigates that the federal probe has officially ended. It centers on the death of Boston police officer John O'Keefe. Both sources, who spoke on the condition of anonymity, says federal prosecutors notified Massachusetts State Police, the Norfolk District Attorney's Office, and the Canton Police Department last week that no charges will be filed. One source said they expect Norfolk County Special Prosecutor Hank Brennan to announce the development when Reed returns to court Tuesday. We'll have to wait for Mr. Brennan. The federal probe was run by the U.S. Attorney's Public Corruption Unit, and agents from the Boston FBI office assisted with it. Do we know that? Like, when did we find that out? I could have sworn we didn't know anything about the federal investigation. Like, we didn't know if it was into Karen Reed or if it was into law enforcement. Or was I just like behind? Yes, Corey Richards. Oh my gosh, I have so much I want to cover with Corey Richards. Yeah, I have a lot that I want to cover with Corey Richards. Holy moly. Court schedule. Corey Richards. So we caught up with Donna Adelson. If you guys haven't watched my Donna Adelson video, watch it because we got a Donna Adelson hearing. Is it today or is it tomorrow? Donna Adelson. Donna Adelson is tomorrow. Okay, so Donna Adelson's happening tomorrow. The reason why we're having a hearing for her is because she wants to be out on bond, which is wild, right? Because, you know, this woman was caught literally at the airport while she was trying to get a flight to Vietnam. Was she trying to escape, you know? Was she afraid that things were starting to come down and Charlie was convicted? She might have been next. Harvey might have been next. So she wants to be out on bond. Apparently, she's being bullied in jail. She doesn't like the jail conditions. Food, obviously, is not good. But she's saying, like, oh, the reason why she's complaining about food is not because she personally doesn't like the food. I think she said it's because she was trying to get Harvey to send her food. That way, she can give it to the people that were threatening her in jail. And then also, she talks about, like, her injuries. They weren't addressed properly by the medical staff. She's having terrible time sleeping. The sleep schedule is really horrible. She's not sleeping at all. So she wants to be out on bond until the trial happens. And she's like, I'm not at risk of, of fleeing the country. Me? No way. You took away my passport. But people make fake passports, don't they? Anyway, so she's going to have her motion hearing tomorrow. And if you guys just want like a huge catch up on that, watch the video that I posted last week. I think it's fairly short. So we have Adelson stuff. Yeah, today I'm going to catch up with Corey Richens stuff then. Because Corey Richens, I think, has a lot of stuff happening right now. Like, I went through the case, the court's website for Corey Richens. I'm like, oh my God, there's been so much shit filed since I've checked. So we'll definitely, we'll definitely be covering the Corey Richens trial. That's going to be, I think Corey Richens and Karen Reed trial might overlap a little bit. Because Karen Reed is probably going to, no, actually, wasn't Karen Reed's trial like 6 weeks? It's definitely going to overlap. Yeah, Karen Reed's trial happens April 1st, and then Corey Richens is April 28th. April 28th. Well, I mean, there's been some couple days of jury selection. I think there'll be like a tiny bit of overlap. Corey Richens, yeah, hers is April 28th, and it'll carry on to May, to the end of May. But yeah, I have a lot to follow up. That woman is disgusting. Dude, she is like, she hits all the check marks of an alleged killer, okay? Like, there's accusations of her cheating. She, like, incriminated herself by possibly writing diary entries. There are text messages. Like I don't know, like, everything. Like, I should just make a list, because every time I always reference, I always forget. But, man, she's, like, done boom, 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 boom. Like, everything that you're not supposed to do. If you don't want to get caught, she's done. It's like, Jesus. Lots of horrible stuff. And I think there was like an investigation that opened up against her mom, because her mom also had a partner that passed away from, I think, a drug overdose. And so I think they reopened that investigation to see, was that a drug overdose? Was it a homicide? Was it, what's going on here? Is Corey Richens learning from her mom? So, I remember that was being reported. I don't know if there's been a conclusion to that or if that's just still pending. I'm assuming maybe still pending. All right, guys. But yeah, that's about it. Yeah, I guess catch up on the Donald Adelson stuff by watching my video. And then if you guys don't know what's happening today, I think my Karen Reed video is probably like 30 minutes to 45 minutes. So you can watch it during the break, I guess. And then we'll be back together in 30 minutes, okay? I'll see you guys in 30 minutes. I'm just going to have to stream up. And I'm gonna, I don't know if I even have my mirror back screen. Do I? I think I got rid of it. Let's see. We could do this scene, and then I'll add a text saying, be right back. Be right back, y'all. Is it this one? Oh, that's Verdict Watch, not that one. How about remove? What are you guys eating for lunch? I'm actually not hungry, but I know I should eat because today's going to be a long, long day. Although I wasn't planning on covering the other motions. I just wanted to cover this drama. Wait, oh shit, I did the wrong one again. Wait, what does it say? Oh, this is starting soon. Oh, this is the correct one, actually. Oh, why is it so tiny? Wolf, right? Court is on lunch break. Be back at was it 1 p.m. Eastern? 1 Eastern. How did they write again? 1 p.m. Eastern, and then my time is 11, right? 11, 12, 1, 2. Yeah. 11 p.m. PST. Dun, dun. Wait, p.m. 11 a.m. a.m. Court is on lunch break. Actually, I kind of want to do this one instead. Oh my god. What is this? Never mind. We'll go back to this one. We'll use court TVs. Okay. There you go. Oh gosh. Come on. Does that look stupid? Looks kind of dumb, right? Should I just do this one instead? Oh, no, not this one. I'll do this one. I'll close my camera. How about that? Yes. I'll close my camera. And then I'll do... Should I just do this one? Sorry, streaming is hard, okay? Okay, I think this is better. Okay. That way people know it's my stream. I'll write it right here. And then, oh, I usually have an image where, this one? No. Add image. Image number 2, maybe? What the fuck? Oh, that's not it. Why do we have this here? Oh, that's random. Okay. I could have sworn I had one where it was, oh no, that's not it. Oh, that's old, actually. All right, I'll just do this. Oh, is it? Oh, I think you're right. Sorry, I meant 2. Yes. Thank you. 2. I knew the math wasn't mathin'. Thanks, Shaniqua. I appreciate that. Okay, 2 p.m. Eastern. So 11 a.m. Pacific time, 2 p.m. Eastern. Thank you. People would have been like, what is this? Where is everyone? And then I could do another. Man, by the time I'm done with this, I feel like there's going to be back. Let's see. Let me add one more thing. Add text. Text number 2. This is verdict watch, but I'll fix it in a second. Okay, how about that? Quirky on lunch break. I mean, technically, I'm not. Anyone's gonna eat a cereal. I'm technically on breakfast break, okay? But I think breakfast break sounds weird, right? It's not a thing. I don't think so. All right, guys. See you guys in, I guess it's 20 minutes. I'll see you in 20 minutes. Oh, yay, they're back. Okay. I am back too. Why is it so dark in there? How was your guys' lunch / breakfast? Hi, CMB. Hold on, let me turn on all of my stuff. I was trying to configure my camera settings. I think my dog kicked my camera too.
May it please the court, I first want to thank Your Honor for the generous amount of time you're
No
according
need
me.
to thank me. Just go right ahead, sir. And take your
What did she say? No need to thank me? Just let him thank you.
Time you're
No
according
need
me.
to thank me. Just go right ahead, sir. And take your time, Mr. Leslie. I shouldn't have cut you off. I appreciate that, but take your time. This is important.
Thank you. So, Your Honor, I left off with page 58 of tab 8, which is last week's hearing. And what I want to do is to go to, because I'm going to go backwards ever so slightly because it's an important segue to returning to page 58.
All right, we
So
are
I
there.
referenced the court to page 57, line 11, where the Commonwealth said, response, in quotes, "Hi, Ellen, subsequent to our conversation on Wednesday, the U.S. attorneys," and he's quoting purporting to quote the, and it's good to have, if Your Honor can be, having tab 1, which is the March 22nd email, because I'm going to compare and contrast tab 1 to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yes, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date. Is that what's best for the court?
Yes.
Okay. So the March 22nd email, I've dubbed the pause email,
Yes.
and because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept, because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, etc., etc. So compare that, please, to the quote,
I love all the highlights in there.
reported quote on page 57. 11, "Hi, Alan, subsequent to our conversations," he's quoting purportedly this email. "On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?" Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And it's not merely semantical, it's the cutting off of communications. And it's unfortunate that that pause was not quoted
So you're saying Brennan read it incorrectly by excluding the word pause.
on page 57.
Did he?
Now back to page 60, or excuse me, back to page 58. And this is where I left off. Line 2, now this is an information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications. That's not accurate. And Your Honor, what is important to note, Your Honor asked about when did
But I wonder if when Brennan said the defense provided the outline, did he mean that the defense provided the outline that Dr. Wolf provided the outline with? right? No. Did the defense provide the outline that Dr. Wolf provided them? I wonder if he meant that. Or did he really mean it was the defense that made this outline, not Dr. Wolf?
Defense provided the discovery.
And you told me the 12th, right?
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand, to be as accurate as we can. I'm the one creating the standard that every word counts, every day counts, so I want to try as my best. I may get something wrong, but I want to try my best to get it. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank.
Okay.
That's the first name on it. 2 Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay. What time of day? Because if it's California time, it might be different than what we have here. But
It probably will be, but I don't know what time of the day. I'm going to ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
okay.
And so, but suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's assume worst case, it's therefore in effect the 14th. That's 4 days before the 18th that this is sent. And what
Do you have a time?
Pardon me?
Do you have a time, Ms. Little?
Yes, one moment.
Thank you.
I don't know. My stomach is
And
feeling.
I'm understanding Your Honor would like me to pause until you get that.
If we can, because I'm looking at a
Absolutely.
calendar. If you don't, I thought you may have had it. We can move on.
It's approximately 6:30 in the evening. It was received by the Commonwealth.
Thank you.
And is that, may I ask Your Honor if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Ms. McLaughlin.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
Okay.
So also, in big bold letters, at least on the printout, the subject is Karen Reed - ARCA reciprocal discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, ARCA reciprocal discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confirm with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like ARCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much, how is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we
I think
move
it's
on.
miscommunication.
We move on to page. So there we have with on page 58,
Not miscommunication from the Jackson law firm, but miscommunication within the Commonwealth, or maybe Hank just fucked up. Maybe he just misremembered. Maybe he was confused. But
we
I'm thinking more
have another
miscommunication.
incorrect statement. We have two of them right up off the top, and then we continue on to page 59. Your Honor, understandably, says the court. What is the date of that? Mr. Brennan, it's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second. Let me make sure.
Oh, I
And
think
Your Honor, if I
so.
may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
That's what we thought the outline was, maybe like an
So Your
attachment.
Honor, appropriately and understandably, says, what's the date of that? Here's the answer Your Honor got. It's not dated. It's not dated. Now, let's please just go back to tab. We're talking about the outline. Let's go back to the outline.
Is it dated?
And we can pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just pausing to make sure
I
you're...
have it.
Thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
Yeah.
Subject-
So that itself is not, I understand it's with the email, but it's not dated.
Well, Your Honor, I was going to get to that, but there's context for that.
Okay, go ahead.
The context, you're correct. The outline itself is not dated. However, the attachment, keep in mind, we produced these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just
Yes.
because I don't understand? So what I have separately is the script and then something saying qualifying the expert. Is this all one document?
No, Your Honor.
All right,
And
so
I appreciate the question.
What
So-
is the date of the, so you're saying what I refer to as the script was sent on the 23rd?
That is correct, Your Honor.
What was the other one? When
The other
that
one was
sent?
sent the day before on June 22nd.
Okay.
I'm just going to give the name that the email has. I think it's at wolf_quals document. Okay? So there's two emails. One's just the quals. The other, respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says in the title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual quals document or the direct document. We produced them in this fashion, and I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email,
Okay.
the last sentence is, I will try to work on some direct examination questions tonight. So you know that when the direct comes in the next day, I think the only reasonable conclusion to make is that that direct outline was created after the 22nd, or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that I
Let me
just
actually
went.
hold that thought. I just have one other thought about
Yes,
this.
please.
So we're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
and you are
correct.
saying that this was disclosed prior to the February 18th hearing. But was this disclosed prior to the witnesses' testimony?
The answer is no, Your Honor.
All right.
The
I
answer
just
is
wanted
no.
to be clear. That's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate.
Okay.
And I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay.
So now, if we could please go back to page 59.
I'm there.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA. There's another okay, so to speak, with ARCA. Or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less, blah, 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 blah. Now, here's the next one. Another comment. He's quoting, would it be fair to say, because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Now, and then yes, unfortunately, there is a direct correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm sorry, thank you. Fatalities occur during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it. They had that. What's the objective evidence that they had it? I go back to the Voir. They had it 4 months ago. 4 months before last Tuesday. They had it before we turned over the discovery. And what's the objective evidence that they had it? Is the voir dire of June 18, 2024 of Dr. Wolf that I referred to earlier.
Hold on, I will be right back. Give me a second. All right, I'm back. All right, what was Alessi arguing?
Page 167, line 12.
Go back a little bit.
Sorry, thank you. Fatalities occurred during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it.
Yeah, they
had
did.
that.
That's
What's
what I
the
said.
objective evidence that they had it? I go back.
Well, I guess because I think what Brennan was thinking was maybe before the voir dire, it would have been nice if Lolly had that information. Oh no, but then no. Because Jackson apparently didn't have that before voir dire. That's right. It wasn't until after the voir dire. So during the voir dire, Jackson elicited that testimony out of Dr. Wolf, and then after voir dire, it was when the outline with the notes in the margin that came out, and then the testimony. Yeah. Okay. Because then I remember Brennan was like, "Oh, that would have been nice to have that," but it was brought in voir dire. I don't think Lolly did any follow up question in regards to nighttime and pedestrians, and I don't think Lolly did it again in cross examination.
Back to the voir dire.
But I think when Brennan was presenting this, I don't think Brennan knew when. Like, I think Brennan just accused the defense of possibly just working with the defense before the voir dire even happened. I think that's what his thinking was.
They had it 4 months ago. 4 months before last Tuesday. They had it before we turned over the discovery. In which the objective evidence that they had it is the voir dire of June 18, 2024 of Dr. Wolf that I referred to earlier, page 167, line 12. This is Dr. Wolf. Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian is coming down the roadway, etc., etc. But that's not the end of it. They had it twice. So if we go to the direct...
Testimony. Yeah, I brought this up in my video that I made last week, but I think Hank was just working on the assumption that defense and ARCA were working together before voir dire happened.
Testimony of Dr. Wolf that I referenced earlier. This is my tab 6, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolf. Page 36-65.
Okay.
Line 22. This is Dr. Wolf's answer. Several hundred, period. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. There it is.
I did see that.
So let's go back. That's misstatement number 5.
Maybe they watched my video. Just kidding.
It would have been nice to have. I agree. It would have been, and you did. Twice. Next.
But you know what will be interesting, though, if there is a new group within a law firm. Basically, these are people that just like watch other YouTubers and commentators, or maybe even look at like YouTube chat to see if there's anything they missed, if someone brought up something that could have been overlooked. You know, I feel like there's going to be like, I don't know, law firms are going to like hire like a team that just like scours the internet just for shit, you know, especially during trial and all that stuff, because you never know what the internet might bring up that they might have overlooked.
Reading on the same page 60, he's quoted. So, my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. That's the end of the quote, and then the Commonwealth takes on with a commentary. Pretty important stuff in this case. I agree. And you had it twice.
Oh,
and then he comments,
from
if
Mr.
you
Lawley?
don't want me to say this, that's fine, that's fine. Then the commentary from the Commonwealth. Shh. And I went back and watched the video. Shh. Don't tell them. I'm sorry? What do you mean don't tell them? You were told twice. In the voir dire and in the direct. In the direct it was just unvarnished. And here's the important part, Your Honor, another important part. Mr. Jackson drew that out on direct. not only was he not shushing or hiding, it was Mr. Jackson's question that drew that out. So here you have Dr. Wolf trying to figure out, is this something that we should say or not? And honorably, Mr. Jackson, no, we're going to hit it head on. Mr. Jackson.
Man, I wonder if Hank went to Lolly, was like, hey, do you remember during voir dire and during testimony, if they ever talked about this like nighttime visibility thing? And then Lolly was like, no, they didn't. Yeah, they didn't tell me anything. They didn't bring this up. And then Hank just went with it instead of double checking the transcripts or like checking the video or something. Oh gosh, this is why it must be so hard to just jump on a case after shit has already gone down. Because damn.
Jackson draws it out, puts it right on the table. 4 months before February 18th.
That happened in Recovery Addict stream of a trial. I forget which one, but he had given ideas that made it to his stream and give him credit for it too. Oh, I think I'm familiar about this. I think I heard about this from someone else. Was it Melanie Ferris trial? Something with a gun?
And the whole world heard it live. Next, if you could, Your Honor, please go to page 60. I'm sorry, there's another point at the no, let's go if we could. I don't want to take the lesser significant ones. I want to focus, because there's many of them, I want to get to the more significant ones. So then we have on page 60, line 2. And then a bill from ARCA to the defense for $23,925. That's not a trial by ambush. That's getting duped. So I, Attorney Brennan, didn't know any of this. But I've tried a few cases, I've been around the federal court a bit, I know how it works. So what is the import of that statement? I didn't know any of this until I got it from the federal government. And we're talking about the invoice. No. You know about it because the defense, after the certificate of completion of discovery, in 6 weeks before the trial is starting, the defense affirmatively turns it over and does it not buried amongst several discovery documents, but essentially a tailored discovery response that's titled
Karen Reed ARCA?
Karen Reed ARCA Reciprocal Discovery. That's not a very good way to try to cover up something. There is no statement about the date of the invoice on February the 18th. So people are left to wonder, when did it occur? When was this bill stated?
Right.
The date's important for that invoice. Then there's a lot of statements made, sometimes parties pick sides, it creates blah, 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 blah. And then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts, illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here. The illusion, and it's more than illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion, it's a statement of fact. Statement about federal investigations that were these are not ghosts, we're not creating it, but I'm not going to go any further on that topic. But the ghost word was used, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpret it as, you're preventing us from getting this information, defense. And this is 5 days after we had provided it. Next line. page 60, line 13. I don't care if the ARCA witnesses testify at trial. I'm very pleased to hear that. I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden. Hidden. And that is based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with that. The Commonwealth is entitled to discovery, and you got it 5 days before February 18th. Now comes to the court. All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what
Time to pee.
I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and, frankly, of the moment in this trial. And the reason I got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this and the court staying a break is, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the several and serial inaccuracies, the break right in the middle, and then the court comes back. And I understand, I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about, facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit. And I've had this issue before with other motions under what's required in an affidavit. None of
In this case?
No,
Or
I'm
are you saying
talking-
generally, you've had this issue in other cases, or do you mean this
other
case?
cases, other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct. And Your Honor takes the break, so we didn't get an opportunity to stand up and say, what I'm being given the very fulsome opportunity to say today. So Your Honor comes back. All right. So the Commonwealth just provided the court with information. And I don't even want to repeat these words because it almost pounds on to the prejudice to the defendant. But Your Honor well knows what Your Honor said. But it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest, so be back in here. Unfortunately, that's not the end of the prejudice. So what happens is, all of a sudden, and Your Honor basically said, and this is all so key, so you said, I'll see you in a week from today, and then Your Honor continued on page 61, line 12. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there and check with whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read?
Hey, go lucky.
It was only then, when the the reality hits, that you're looking for the backup for what's being said. Up to this point, Your Honor's understanding, all of this came from the feds and the defendant didn't turn it over. So what does the Commonwealth do then? Does the Commonwealth stand up and say, whoa, wait a minute, I made a mistake. And Lord knows I've made mistakes before. They didn't stand up and say, a very significant mistake, my whole predicate for my whole presentation was, I had to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court, I might have asked for a sidebar and come up and said, Your Honor, my bad. You know, this is that. But that didn't happen. So what did happen? The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another TUI request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. Buried in a chronology is, and in the middle of a sentence is, the defense provided us with the emails. I think I said, I'm going to repeat that. I think I said, the federal government, it was the defense. February 13th, they sent us the emails in the direct examination outline. I think I said, that was the whole basis for the entire presentation, was that the Commonwealth had to fight even the feds to get that. And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14? What was not corrected? It wasn't corrected that the invoice came from the defense. Just emails.
I thought it meant everything. But
Yeah, me too. That's what I
I
was
don't
thinking.
understand how that conclusion can be drawn, Your Honor. It didn't say the defense provided
Because wasn't the invoice also emailed as well? That's what I was thinking.
us with all of the entire production. The defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached out to the
because
federal.
I received a copy of it.
Pardon me?
I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, you got to correct a material. And I've got it in front of me, but I'm just paraphrasing. I want to get to precisely. But that's why I perseverate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do, but if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this. Being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 15. We reached out to the federal government again because I was curious about the change in position on February 6th that the contract was ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement because you read it because that would naturally preclude the defense from retaining them, yet at the same time the Commonwealth for the fourth time has moved to strike our ability to use ARCA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I hearken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements. 10. Before Your Honor caused the pause. So, coming to what happened then. The Commonwealth, having not given us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got. Because I do believe that Your Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for myself. That's the way I took it, and I appreciated that. Because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is, what are counsel saying to the court and isn't accurate, I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just want, and today, but I want to make sure that I recognize Your Honor's giving us that week, and we've tried to take the best opportunity for it. So what happens? What happens after these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided had there been an accurate recitation of what had occurred. And Your Honor, I don't know if this can be remedied. But it surely shouldn't have been exacerbated. I would now like to move rather, hopefully, efficiently through the next step, which is to point to the Massachusetts rule and give the court my view, and I have to reference, because Your Honor brought up some...
Again, you don't have to tell me what you're going to do, Mr. Leslie.
I'm sorry, I'll just go ahead and do it. My apologies. So now let's just turn to...
Just how he does things. Let him do it the way he wants to do it.
Model Rule 3.3A1. And this applies to every counsel in this room, of course. A lawyer shall not knowingly, so there's the adverb of the mens rea, knowingly, make a false statement of fact or law to a tribunal, or
Hey, taxi.
fail to correct
Isn't it late
a
right now?
false statement of material fact or law previously made to the tribunal by the lawyer. So we all know the mens rea of knowingly. And this court knows it better than everybody, so I don't have to get into that. But in terms of make a false statement of fact or law to a tribunal, I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th, since we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've gone through and the statements that were made, especially on June 10th, they were 100% true and accurate at that time. They were 100% true and accurate, and that's why I went through the note. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing a statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like you make a misstatement, it happens, but you got to correct them, right?
I'm getting an English lesson.
And what they talk about is, what do you have to correct? You have to correct a false statement, so it has to be false. It has to be knowingly false, of material fact or law. And material has been interpreted in the context of 3.3A1 to be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. It's essentially what the case law talks about, that it's influenced the judge's decision. So let's go back and even let's assume hypothetically that on June 10th there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses. And that is why I spoke about Mr. Yannetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making to correct the statements. So I go to the analysis with regard to 3.3A1, and as I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses, as the court knows. But I want to hit one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs, if Your Honor feels differently based upon what I've said. Or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time?
I don't. I have taken the time. I appreciate the offer.
You got this.
But I would like to draw your attention, Your Honor, because like I provided context on June 10th, I think context for February 6th is important. And so what I'd like to do is to go back.
What's the hearing about? Gosh, it's a long one because it has to do with what happened last week. I did make a video about it last week, but essentially just whether or not we're going to allow ARCA experts to testify for trial number 2, whether or not the defense did something wrong, whether or not the state misunderstood or misrepresented. And that's basically kind of the gist of it. Yeah, a very small, tiny little gist of it.
Back earlier than what Your Honor quoted this morning, because I think the context is important.
All right, so I have that entire transcript, like I said.
Thank
What
you.
page are you at?
I am starting on page 40.
Okay.
I start with line 1. Mr. Brennan, correct. I had a conversation with one of the 2 prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with, no, okay, I received it, I sent a TUI response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then Ms. Bugalton, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite their testimony, they've complied with Rule 14, and so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled under Rule 14. I will at that point move to preclude the witnesses. So I think the important in this snapshot in time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government, and we didn't turn it over. Your Honor obviously has read the February 18th transcript. You can draw your own conclusions. But on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on. The court. Move to exclude the witnesses? Mr. Brennan, yes. The court. What do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court. I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right. Last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire of these witnesses, it seemed to me that that was the logical conclusion. I'd be able to get both sides discovered. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than wait. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them, is that when you want to exclude it, so I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson, and this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols.
You wonder how this trial will work out this time, right? That's why I'm so curious, because initially I was like, I'm not going to watch trial number 2. Like, no. But then I found out that Lolly is not going to be the main prosecutor. It's going to be a different prosecutor. So I was like, okay, maybe we'll have something different this time. We got some new experts. So I do want to watch trial number 2. Although I know there's going to be a lot of repetitive testimony that we've heard from trial number 1. But yeah, I want to know, what new experts are they going to hire? Hopefully they ask a lot of the older experts, but we're going to have issues with Trooper, Proctor.
So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th when we would get the certificate. We had the certificate of completion of discovery. We had 30 days, technically, to turn it over, but it got turned over on the 12th. So then it continues on, is important, the court, if I don't exclude it with other side seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided. The federal authorities provided all the discovery that was attended to their analysis and testimony. So what we have in terms, Your Honor, this is important, and I'm going to go right back to 3.3a. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those items. That was Ms. Little's responsibility. So what happens? What happens is Ms. Little handles the production, goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth. On February 18th, the defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why.
Is there anything new about the FBI investigating law enforcement? Yeah, they actually concluded their investigation. That's been reported today. And they are not charging law enforcement. I don't know if it's like they haven't charged law enforcement yet, but there's been no charges for law enforcement. So I'm assuming they're not going to go after law enforcement. And that's it. They've concluded their investigation.
Why it is important.
Apparently, Hank Brennan, whenever he goes next, he's supposed to announce that. That's what the article said.
Because
that's what the
whole issue of discovery, the whole issue of batches of information was provided. And it was provided well before the 18th, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're going to collect, here's what we're going to turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any reading of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct. We had the clause. Not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when, and so with regard to the shall not knowingly, there's no evidence of knowingly here, and I don't believe, respectfully, there can be an inference stated. When I've looked at every single case where the court can look at the circumstances. So knowingly is not merely a subjective question of what an attorney has. The court is entitled to look at the circumstances in this. The case law says should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is unfortunately a woman attorney who was in a bad divorce. She had financial statements, and she made misstatements of fact about her financial statements. And then the question became, did she knowingly know it? And what the court did, she said, no, I didn't know it, I didn't remember it, I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she did. So there's an example of you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So in turn, and that's the February 6th, respectfully, that's the only aspect, and I went through all the others, that even comes close to a false statement of fact by Mr. Unetti or Mr. Jackson. In sum, Mr. Unetti's statements on June 10th, all completely accurate. All completely accurate. Mr. Jackson's eliciting of the direct testimony at trial, when he asked, have I ever asked you specific, questions, etc., that's completely true because it was Dr. Wolf who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14, which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows that the discovery came from the defense.
I have no idea. No idea what's going on with people. I feel like there are people that are just like either just like selling their land as is, but then having to deal with insurance. I don't know. There's this guy that like rents like a portion of our garage. He said that he had a friend that his house didn't burn down, but there was like severe like smoke damage to his house, like the insulation and all that. And to get someone to come and clean it, it was like $200K or something. And then it was a battle with the insurance to get that covered. And yeah, that person feels like maybe their homes just should have burned down. It would have been easier to deal with, but I don't know. I have no idea. But yeah, I did hear the fire chief was fired, or I don't know, they fired her, or they just like, demoted her. I don't know, because I'm hearing different things, but I want to know more about Karen Bass and the fire chief, because I'm wondering, is Karen Bass just throwing the fire chief, under the bus? Is she going to be the scapegoat, or did the fire chief really fuck up? What's normal protocol? Because I know the issue was Mayor Karen Bass was trying to say that the fire chief like let 1,000 people go home that day for the, and there was like a high wind warning, but it's like, yeah, but like how often, what area was this though? Did the fire chief let 1,000 people go in like the LA area, or was it more like I think the Palisades is part of LA, but because the fire is happening here, that's like unprecedented. That was like crazy. That was wild. Fires in Malibu and Palisades, that's already something like you kind of knew that, that they're already at high risk for. But I just want to know, what is the common practice? What do they normally do? Or is just hindsight is 2020? Like, oh, she shouldn't have let 1,000 people go home, even though there's like high wind warnings. Because like we've had high wind warnings before, but I don't know. I don't know. I hate to say this, but there's something about Karen Bass, like something about the look in her eyes. Like, I don't know, man. Like, I feel a little uneasy about her. Something about her. I wanted to do like a whole deep dive about it just because I'm just curious, but that really wouldn't benefit me. It would just be for my own curiosity. But yeah, I hope someone makes a video about it. Because I want to know what's going on. I wonder if the fire chief is going to speak out again. Because the fire chief, she was speaking out a lot. And then, her and Karen Bass had that meeting. And then they were like, yeah, she's not going to speak to the press anymore. I'm like, I wonder if Karen Bass is just trying to get her back, I don't know. I'm wondering what's going on. But what I want to know is, apparently there was a landslide that happened in Karen Bass's neighborhood, and her neighbor's house got like completely destroyed. I think Karen Bass, I don't know if it's like lip service or if she really meant it, but like she was gonna like help, the neighbor, the rebuilding and stuff like that. And I want to know what's the fault with that neighbor. I wonder if the neighbor, should I have this message pinned? I want to know if she truly did end up helping the neighbor out in that landslide thing, or if the neighbor just got fucked over and then, Karen Bass said she was going to help, but then really didn't. I don't know. I want to know more about that. I
want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARCA from defense counsel, because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript. I am on page 62, line 18. Obviously, and by the way, this is toward the very end of the 18th. Obviously, the Commonwealth is in no position to contact, etc., etc. And what does that relate to? If Your Honor would go back to page 60, line 13. And it's a repeat.
I heard that there was, oh gosh, I'm trying to remember the numbers, but I don't think they're being sold for cheap. There was a property, it was a house that was burned down in the Palisades, initially listed for, I forgot what it was listed for, but they basically got over asking price. So I don't know, maybe the guy, when he listed the pricing, maybe he just like did a lot lower than what it's initially should be for, but I don't know if they're getting it for cheap. I don't know. But I just remember seeing that one article that someone had listed their property for sale and then they got like over asking, which is good, I guess. But yeah, I don't know. I guess like what I'm scared of is because we already had this issue with LA during like after the pandemic. So after the pandemic, interest rates were like 0%, and then like they rose up a little bit. It was just like super low. So a lot of there were a lot of developers who were borrowing money, and then they were developing all these like properties and stuff like that. But they were just building like shitty fucking houses, like just shitty fucking houses. And then since interest rates were so low, people are like, oh shit, let's fucking buy. Interest rates are low right now. It's really good. Let's buy while it's low before it goes up. And so there was like a huge demand for all these houses, and then people were building them. And like, I just feel like a lot of the new houses that are popping up are just like really shitty fucking houses, Because we were looking at houses during this time, and it was almost so, I don't know. I just felt like defeated because we're looking at all these properties. They were listed for like super fucking expensive, like in the range of like $850, $1 million. And then like the houses that we were looking at that was $1 million, like they didn't even feel like $1 million houses. It would be like 2 bedrooms, 1 bathroom properties. Like I don't know. And then like they were built in like such, maybe the areas were, because it's in LA, everyone wants to live in LA, but like, God, these houses were just like shit, like completely horrible build quality. And I don't know much about houses and stuff, but build quality, like, shitty build quality when you see it. Like you can feel it, you can hear the creaks, and then like you're like turning the knobs and all that stuff. And like, or like they'll use like wood accent, and the wood accents are just like some shitty wood that they got from like, I don't know, wherever. And then they just like stained it. And of course, months later, the stain will just come off. I don't know, man. It's like the build quality here is just so shitty. And it's because they know people want to come and live here, and people are willing to pay for it. I don't know. That's what I'm really sad. Like a lot of these houses that were burned down, especially like in Altadena area, these were like some beautiful like craftsmen's houses, and beautiful houses that will probably never get back ever again, unless there's someone out there who wants to spend a fuck ton of money, into building these like beautiful houses. But yeah, I don't know. A lot of these LA houses are just like shit houses, just shit fucking houses, like horrible build quality. Layout doesn't make sense. There's this one place that we toured, so fucking hilarious. We toured this one place. It looks pretty, right, on the listing, but when you go there, it was just a complete piece of shit. Like all they did was just like paint it up and try to make it look good. But then like when you talk to real estate agents, like, yeah, we tore it down to the studs, we rebuilt everything. It's like, yeah, you guys, it just looks like shit. I don't know. It just looks like shit. They literally forgot to put outlets in the kitchen. So the kitchen had no outlets. No fucking outlets. And I'm like, yeah, okay, we're leaving. Bye. I don't know. It was just so sad, just like touring these places, and just in the pictures, they look nice. You have like, white houses, you got like the black window panes, you got like the black door, the wood looking floors, like they got the aesthetics. They know how to get the aesthetics down. Gold hardware, but like, dude, when you're touring these places, like they're just like pieces of shit. Just pieces of shit. I don't know. You're lucky if you can buy a home where the owner intended to live in it for the rest of their lives, but maybe they got relocated, new job or something, and they have to go elsewhere and sell their property. So I think those are the best houses to buy, where you have an owner that knows how to take care of their shit. They don't do their own DIY stuff. They hire professionals to do this stuff. And then their intention was to live there forever, but something just happened. They just had to go. So those are like, I feel like the best scenarios. But man, when you're buying these like flipper houses, like a lot of them are just like pieces of shit. I don't know. I wouldn't recommend, if you guys are ever shopping, I wouldn't recommend the flipper houses, because they're just trying to do whatever looks good at the lowest cost, and then they don't care if it's going to fall apart in like 2 to 3 years, 5 years or whatever, But yeah, the outlets were just messing up the glam shots. That's what it was. Oh gosh. Anyways, that's my rant.
But I didn't
Back
get
to
to
Leslie.
the point here. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions. But I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to discovery. Key line. So, if they can produce the discovery, I welcome ARCA. I want to repeat that.
You don't need to.
I'm sorry, okay. So, my point is, we produced the discovery. Why is there still an issue with ARCA? These aren't my words. So, I want to cover, before I get to the Sixth Amendment issues, the point that ARCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have the discovery. They've obviously had from the government a
I was going to speed it up, but court is on another break, so I think we'll be caught up just in time.
long time, everything about ARCA. So I want to touch that base to make sure that either intended or collateral damage, that ARCA still gets to testify, because it's a key part of the defense here.
Oh, really? Same in Munich. You can spend like $1 million for a tiny house that looks like a fucking shoebox. Thanks, but no thanks. I moved to the enchanting countryside over 10 years ago. Never looked back. Oh, I want to go to Germany. I've never been to Germany before. You guys are having your elections right now, right?
Now to the Sixth Amendment. The United States Supreme Court has...
Sixth Amendment, the one where it's like you have a right for like the representation that you choose and all this. Oh no, what's going on here? Stop it. What the fuck? Why did it resize like this? You have a right to attorney, and then you can choose who you want to choose, right?
Has held repeatedly that a defendant's Sixth Amendment right
Protect the rights of people accused of crimes.
to defense counsel of their choice
The accused has a right to legal representation. Okay, that's one of them.
is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, does it correct it?
Oh, I was watching that earlier, with Bruce Rivers reacting to the Luigi Mangione thing. Yeah, I was watching this morning. I haven't finished it yet.
The Sixth Amendment gives way.
Oh, really? Election's over, big coalition, but fringe right-wingers are still a looming threat. If you go to Germany, my offer stands. I will give you a tour of Munich and Bavaria. Oh, thanks.
Two, the
I'm
need
good, though.
for
I
the
just wanna
court
eat.
to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped, and I give Your Honor United States versus Gonzalez-Lopez,
that'd be
548
great.
U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that. And the U.S. Supreme
struck pro hoc vice, or was that not?
I'm gonna get to that. The answer is the counsel. I want to be assured my answer. Yes, and I'm going to read my conclusion because it doesn't say pro hoc vice, but I'm going to read you a part of it. It says, during the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor.
So all these attorneys are appearing pro hoc vice. I think with the exception of Yannetti, because Yannetti, Yannetti is a Boston attorney, so he's local, but he's New York. Jackson is L.A., and then I think Elizabeth Little. I think is she L.A.? I feel like she's from Jackson's office. I don't know. I could be wrong though. I think they're all pro hoc vice, except for Yannetti.
I'm pretty sure, but I'm not 100% sure. And then the following week, et cetera, and then the revocation occurred. And
Dude, my stomach is not
yes,
heavy.
it was. So the Supreme Court holding. Government conceded that Gonzalez's Sixth Amendment right was violated below, where the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted in. It wasn't a revocation of pro hoc vice. There's a difference.
There is a difference, and both occurred in this case.
Okay.
There was both. Good point, both. So Your Honor, and there are other cases when you have the Sixth Amendment, the fact that someone is pro hoc vice status is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here. It's only when the violations that undergird the pro hoc vice get repetitive, get more than repetitive, but go to things that are done that aren't corrected. And
The captions.
the issues that I've seen in my research, Your Honor, is that they have to be the violations have to drive so much to the core issues in the case. It's like suborning perjury, putting people on the stand when they know they're wrong. Literally having objective evidence that counsel had a document in their hand.
The scariest thing for the defense would be Judge Cannoni dismissing Jackson, maybe Yannetti off the case. I mean, I don't know if we're leaning that way. That's what I was thinking initially. Like Judge Cannoni might do that, especially with how she acted in her last week's hearing. So I think they just want to make sure that they can argue, like, hey, like nothing, we didn't do anything wrong. We didn't fuck up here. And then I think that's why he's addressing the pro hoc vice thing on the other case that he cited earlier.
Almost literally at the same time, they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the
Yeah, so like if Judge Cannoni truly believes the worst from the defense team, he's saying that, instead of going with the worst route, there might be some other remedies you can consider, Judge.
Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some.
Wait, did you guys hear about this case? I think a verdict just came in or earlier. Benjamin Elliott told the police he was sleepwalking when he stabbed his twin sister to death. Sleepwalking. Okay. Man, sleepwalking. All right.
Sanctions. That the court look to do them post-trial so that there is not for the trial the bleeding in of those issues.
You guys ever watch what's it called? Step Bros? Yo, they're sleepwalking in that movie. Sleep murdering. Yeah, I don't know, man. I guess sometimes it just happens, you know? Sleepwalking, you just get real violent. I've heard of people sleepwalking and like walking around the house or going to the fridge or something like that.
Into pretrial matters. And
sleep murdering, yeah, that's a new one.
There's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right? And the defendant is not adversely affected by whatever the counsel may or may not have done. But I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court. What happened on February 18th, there were some misstatements and they weren't cured.
Defendant.
I don't want this to turn into, and I'm not making this argument. I'm not making an equivalence argument. I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I've provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say it as a camouflage or a shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we make mistakes. Mistakes have been made clearly by both parties, and I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here.
You had a cool dream last night where you used your intuition to find Cold War dead drop. It was hidden inside a brick wall behind loose bricks. I found several hundred bundled checks from the 60s in it. My favorite dreams, and I actually had this dream last night, twice too. My favorite dreams are the ones where I get to see my dog again, Steve, and then I go up to him and I like hug him because like my dreams feel so realistic to me. So even though I'm just dreaming it, but it feels like he's like there again and I get to like hang out with him again. I don't know. It's like so cool. Like I could feel his like little warm body, little fuzzy ears and stuff like that. Like I had the dream last night because usually like I try to manipulate my dreams where I'm like, okay, I want to dream about this and I want this to happen. And so I've been wanting to have the Steve dream for a while, but I stopped having the Steve dreams. And I'm like, damn, Steve is just like eluding me. Like he doesn't want to be in my dreams anymore. But yeah, I had it happen twice last night. It was like super awesome. It was like, oh my gosh, like I get to hang out and hug Steve again. Like, oh, this little guy. I don't know. I miss him so much. I miss my little dude.
The
Those are the best
issues
dreams.
are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, if Your Honor has any concerns, I would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Yernetti, any questions Your Honor has, I would greatly appreciate it, my presentation notwithstanding. If there's still concerns with the court, we will take them on as best we can, and certainly candidly. Thank you.
All right, I appreciate that. Before I give the Commonwealth an opportunity.
Oh man, we get to hear from Mr. Brennan. I'm looking forward to that. Mr. Brennan, are they back from break yet? I don't know if they are. I don't think so. I think that, oh, they are. Wait, no, Mr. Jackson? Hello?
Respond any 10 minutes.
All rise.
I should probably use the bathroom. Let me do that. You're convinced that many dreams are like tapping to other dimensions. That'd be awesome. Like I remember I would have some dreams where my dreams would be like, oh wait, I'll get to hang out with my brother in my dream, and then I'm like, oh, you're dreaming right now, so our dreams are intersecting. And then I wake up, I'm like, oh boo, I don't think it does. But yeah, dreams are really cool. What I like about my dreams just feel super fucking real. Like if I'm flying, it feels like I'm flying for real. I mean, of course, it's only what my mind thinks flying feels like. But yeah, like flying and all that stuff, like exploring like different worlds, super cool. That's why I like dreaming, because it feels super real to me. I know they say, like, you guys ever watch Inception and how they're like, oh, do you ever realize that when you're dreaming, like there's like writings and like when you look at it, you can never know what it's actually said. I don't know. I got to the point where like if I'm reading something in my dreams, it's not just scribbles or nonsense anymore. It actually is like words on there that actually make sense. Or like, you know, sometimes like in dreams you'll have like thoughts that doesn't make sense, or like if you're trying to solve like a math equation, it doesn't make sense. I don't know. Like, I don't know if it's just not a good, maybe it's not a good thing for your mind to be working so clearly, because I think your mind is supposed to be resting during that period. But yeah, I don't know. I've gotten to the point where like in my dreams where I can like read things clearly. I can like see my own reflection. I know that's like another thing too. Like you're not supposed to see your own reflection. And then also, like if I have a math equation, like say for example, my dreams that recurs a lot is usually when I'm at school, high school for some reason, and I'm like in class, and then like there'll be like a math equation. I could like literally like solve it right there. I don't know. It's like so cool. When you're flying, is your hair blowing? Yeah, it feels so realistic. Like you can feel the wind blowing into your face. You're like, it's awesome. And then like, I'll take a moment. I'm like, oh shit, like this is a dream, but let me look around my surroundings and just appreciate like this cool area that I'm in. Another favorite dream is like when I'm in like I'm like house touring, like a mansion or something, and it looks so fucking realistic, and it's so cool to actually be there. But it's a place that I've never been before. It's just like something that your mind has constructed. But yeah, super awesome. All right, use the bathroom. Get you a drink. Good boy, Shiro. He's such a good doggo. Ah. One time in college, I fell asleep doing a school project. Then I dreamt of working on the project and finish it. You woke up and I spent the next hour trying to remember how my dream. I tried to remember how my dream self-completed that homework. You didn't remember. You had to redo the school project. Yeah, I don't know about that. Doing a whole last project? I don't know about that. They also say that if you tend to not remember your dreams, like when you wake up and you don't know what the fuck happened, they say to drink a glass of water before you sleep. That way you wake up multiple times, and then you'll wake up like maybe after the dream happened or during the dream happened, and then you'll remember it. But I wouldn't recommend that, because getting up in the middle of the night to pee is fucking annoying, especially when it becomes a habit. I fucking hate that. Oh gosh. All right. They've had their break. We are back. Looking forward to hear from Mr. Hank Brennan.
Okay.
I see Mr. Jackson here.
Same questions.
You are unmuted.
What is she asking them? I like your glasses, madame. Thank you.
Seated. We'll be back in
They
a
are
second.
comfortable.
So before I hear from the Commonwealth, Mr. Leslie, I am going to take you up on your offer to ask any questions, and I may have questions for both sides next week. But actually, what I want to do, and you said I could ask questions of other counsel. So while memories are fresh, I just want to assure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Yannetti.
Yes, ma'am.
As an officer of the court, is there anything that you dispute that you just heard from Mr. Alessi? And what I'm particularly concerned about is what you knew or what you didn't know.
You know, what he said was entirely accurate.
Okay? Mr. Jack?
No, not the YSL one, dude, because that trial was so long and there's so much happening. No, I did not. I initially was going to because I think it piqued my interest when the Fannie Willis stuff was happening. That's YSL, right? But yeah, no. This is too much. I think I just have to watch someone else react to it. Like Bruce Rivers will do a react to it. I'll watch that. That's about it. Laura, sometimes I'll watch that. But other than that, no, I haven't done like the YSL stuff. It's long.
Same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure the court did after it looked at the transcript.
No,
I did as well
no,
after
no.
I looked at the transcript.
I did long before I looked at that.
Right. The context of that, what was in my brain when I said we don't have anything.
Jesus, the fire. Damn. All right, let him talk.
The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we referred to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small...
Invoices, payment.
No, nothing. Because the context of what Mr. Brennan was talking about, being frustrated about, were his TUI requests concerning the federal batch of information. And that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Your Honor, if I could, this is the...
Nope.
Okay.
Hold on. Ms. Little, it was just thrown on you that you're responsible for all discovery. But the same question, you, and again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see
Hold on.
provided that day. But as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay. So I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Brennan.
Welcome back, Tan. For some reason, I thought your name was Freddie. I was just giving it. Free YSL, gotcha.
Talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct in this case, you should consider the history of the case, including repetitive violations, 3.6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARCA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARCA left the impression that there was no compensation, no bias, no collaboration. They postured the information that they gave in advance of the second trial, and I'm going to get to the timing of that. But it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing materials that there was information that showed that ARCA was not wholly independent. It's information that was known to the defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alisi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol, another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane. We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and provide information when the avalanche has started is not enough. This isn't just about Rule 14. My effort with the ARCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them, and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations at the sidewalk. And those questions were right to the point. And when we were sidebar, I specifically mentioned, I don't know, a voir dire is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses, and there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARCA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are two requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not.
No, he's not saying the federal government's conspiring with the defense, no. He's saying that the ARCA people were working with the defense. But ARCA is not the federal government. ARCA was hired by the federal government for the other federal investigation into the Karen Reed case.
Hear a word from any of them. According to Mr. Alisi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex-parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Alisi.
It wasn't a request, Your Honor.
You suggested that I called them.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but the point is it is not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead,
I don't know. It's just like something about her tone. I don't know. The tone. I just don't like her tone sometimes.
it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that ARCA's position did not change. It did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that was not disclosed. It doesn't help the first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my two requests. They provided billing, including ARCA billing. There was billing.
Wait, hold on. Oh, clarifications. I mean, I will say, though, he did say, I think I said the federal government. I meant the defense. He said, I think I said. Which minimized, what he was doing. But okay.
Responded to one of my two requests.
Okay.
Or ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my two requests. They provided billing, including ARCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not directly. No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth our motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak, I corrected it, but it is not the source of that information. It is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial, and it is also that information when you compare it to the representations that have been made prior to trial by the defense that has import. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc vitae. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc vitae attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully, to Attorney Inetti. He's a fine attorney, an excellent attorney who I admire. But there is a responsibility so that there are not a number of pro hoc vitae lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mince or put a slight on words to suggest that things are done independently and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alisi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal material. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge, essentially, of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask the counsel if there were any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over
inquire.
there, please.
Yes.
All right, if I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've heard.
May I have a moment to speak to counsel?
Sure. All right, I appreciate
I'll need to call the United States Attorney's Office and get an answer for
All right, I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replied
It's not me, it's her.
on the 24 saying the U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like that would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the voir dire, where it was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26
You
of
know
trial.
that, but what date?
June 5th, 2024, discussing scheduling and voir dire hearings. The defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. Response, certainly, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross on the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the contents of the report. And those are definitely questions I'm going to ask, so I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? There's day, I'm sorry. What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number for the court.
That's okay.
This seemed to directly contradict the theory that Attorney not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Alisi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts in ARCA, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, and this is June 10, 2024, trial transcript 28.
Hold on one second, let me grab that.
Yeah, and there were 3 experts, but we only heard from 2.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continued questioning, you were told, well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important for the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. On June 18th, 2024, the voir dire hearing. The court asks, well, I thought that you would help.
I've got the transcript. What page are you on? Do you know?
No, but I can.
If it's just your notes, that's okay.
I can pull it up, Your Honor. Page 4, line 11, the court asks, so the understanding of the voir dire is that this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rentschler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct. refraining from my opinion and characterizations. Unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the voir dire hearing, page 71.
Okay.
Line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning when you walked into court, have you and I ever met face to face? No, sir. Now this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality?
Man, do you think we're gonna hear from the ARCA guys?
Line 20, the person to my left, the female to my left sitting here, have you ever seen her before?
Get the
No.
ARCA guys.
Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARCA are wholly independent from each other. This is also consistent with their representations regarding payment. There are questions, voir dire, and at trial, about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence, information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice dated July 12, 2024, that's addressed to...
Hold on one second, please. Okay.
It's addressed to Attorney Jackson, and the position that the defense takes, Attorney Lisi takes today, is this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert, other than the defense. ARCA experts knew. Dr. Wolf knew. Dr. Rensler apparently knew. The federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representation that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, and they wouldn't have been keeping track of their time back on May 1st, 2024, participating in a telephone call with Alan Jackson.
Hey, Chunky.
And so the March 20th email asking for an engagement letter and a retainer, and then the 24th saying we need to take a step back because of the U.S. Attorney's Office.
22nd.
I'm sorry, 22nd and 24th. There is obviously more communications because the relationship re-engages at least on or before May 1st, 2024, and these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office on February 12th, there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses apparently was the defense themselves. And then before that June 10th hearing where the representations were made, there's a June 9, 2024 phone call. Another participated in telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which is now being paid by the defense, prepared for voir dire testimony, June 17, 2024. Another participated in telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which is now being paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Was there any outlines? Was there any discussion about their potential testimony, or is this solely the preparation of Dr. Rentschler on his own? On the same date, 3 hours billed by Dr. Wolf prepared for testimony and hearing. Now, they felt inclined and prepared for testimony and his own. On the same date, 3 hours billed by Dr. Wolf prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for it. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial. 23rd, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony, it is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, there's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and then there's expenses for June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track of the bill that they send within 1 month of the defense that gets paid that Commonwealth and the court never knows about. Talk about correcting a record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness. We have no writing, no email, no correspondence, nothing to support or put in context the conversation, nothing. Nothing. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story. A fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when you look at the totality of representations made in court, we also, at some point, are going to address the Commonwealth's position of violations of 3.6, separate motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asks Mr. Jackson about paying the bill. And what I'd suggest more 3.6 activity. Quote, no, of course not. That was the position last week. So what we're left with is we still don't know the relationship between the defense and ARCA. We don't know about the impact it had on the first trial. There has been these multiple representations that ARCA was independent, they had their opinions and they were exculpatory. ARCA's opinions changed. There were 4 opinions. And if you look at their report, and I'm not going to read it for the sake of the press and the public, we'll have a trial and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question is going to be, why? Why did they improve? Why did they...
particular page you'd like to have without citing?
If you look at the first page.
Yes.
Yeah,
You don't have to read any of it, you just tell me the paragraph.
Yeah, I think it's just the first paragraph that lays out their findings.
Thank you very much.
And actually, particularly note number 4, and both publicly, repetitively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at
Sorry, rewinding it back really quickly.
and actually particularly note number 4, and both publicly, repetitively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at the last page, which is signed by all 3 of the experts, Mr. Wolf, Mr. Renshaw, and Mr. Klein, says essentially the same thing. So we would be oblivious if we stood here and said that the relationship between the defense and the experts, there was no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared. It isn't just what's in that outline. It's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations, communications the defense had with the ARCA experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelled.
Is he asking the judge to
Your Honor
compel
mentioned
them?
the sidebar,
Which one?
the most recent one.
Okay.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not.
Wait, he said you can laugh, but I'm not.
It has been my effort to get Rule 14 material. It has been my effort not to exclude
Someone
ARCA
laugh?
witnesses. It has been my effort to try to achieve fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
All right, thank you. Mr. Leslie, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief. And I hope we get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points. Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they had been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to be providing testimony. That is a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it. We don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court. But to be clear, the reporter asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just told that I paid for their time. That
No,
was not said, right?
That was not said, but I'm saying there's always some inference about being what he said that what was said, but that was his response, that was it. But it was only, the premise of Attorney Brennan was what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things that I'm going to go through quickly is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics. Attorney Brennan talked about 3 witnesses, right? And he was, I believe I took it as clearly inferring 3 ARCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCA people. I
No.
didn't go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion, way early on.
Who is Mr. Klein?
He was a 3rd ARCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony.
I could have sworn my impression was the 3 ARCA witnesses too. And then it's like, which of the 3 of those are going to testify or something like that? I don't know. I could be mistaken.
Okay.
Let me be clear on what I mean by retained. He didn't testify.
It's been a long day.
I understand. I'm trying to answer your question, Your Honor.
I know, and I realize that you just said something that you want to explain. Go ahead and explain.
Right. So what I'm saying is, in terms of, I'm going to take back the retained. The point is, there were originally 3 ARCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler and Wolf. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this third person that was being discussed.
I guess I want to know, why would ARCA, because remember how ARCA was asked by the defense, like, oh, your report is completely independent, which is true. Defense had nothing to do with it, true. But then they asked, you haven't been paid by defense? He says, yes. And the work product was not provided from, okay, it was mostly like have not been paid by the defense. So the ARCA people said, yeah, we haven't been paid by you. But then they must have known that would have been a misrepresentation if they were planning on billing the defense after the fact. Unless they really didn't know they were going to bill the defense afterwards and they thought something happened after the trial where they're like, oh, actually, we should bill the defense for this, not someone else. I don't know. I'm very confused. Get ARCA in here.
And clearly, the inference was that we were misrepresenting still about which ARCA witnesses because we weren't talking about the third. The third was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Mr. Unetti, that's what I meant.
Thank you for bringing that up, Your Honor. And that was just ARCA. That was nothing to do with Dr. Russell.
Oh,
but
okay,
here's
that's
the important
ARCA.
part. Attorney Brennan didn't read the rest of it. You're to believe...
Okay, so where are we? Are we the June 10th?
Yes, please, Your Honor. June 10th. That's exactly right. That's exactly right. It was June 10th. It's important. He stopped when he...
Page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's 100% true, because
I read that earlier.
Right, but Mr. Brennan just mischaracterized it again because that is 100% true. He made it seem like that was an untruthful statement, and I know Your Honor gets it. The other last 2 points, Your Honor. Attorney Brennan talked about that the ARCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little, and I spoke with Mr. Jackson, and they're going to be completely available for any questions that follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Crononi was asking about,
I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little, who would, between the two of them, would, if there was any recollection. So during the break, I asked Ms. Little, I said, Ms. Little, when you heard, got the order, because that's the first she knew of the inquiry, she gets the order, I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there are these March emails? And she said, no. I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back. I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.3a. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, neither did Ms. Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3a1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question from whether the attorneys are in compliance with 3.3a. And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor. It was said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it, and I'm going to give you another cite, Your Honor, which is United States versus Diazzi, that involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable, and yet the court held that you could not disqualify them because of the Sixth Amendment. And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where a defendant, their choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said to be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brown?
Very briefly.
Everyone just seems so over it and tired or something.
My arguments to the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in a pleading.
That was filed
On
late, right?
February 6th.
Saturday or something.
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alisi, Attorney Manetti, certificate of service by Attorney Little.
Was it signed by Ms. Little? It's not,
Ms.
right?
Little has
It's
only done the
maybe
certificate of
authored
service.
by- Okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Yannetti. And this is the defendant, Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant, Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA LLC, namely Daniel Wolf, PhD, and Andrew Rentler, PhD. There's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent.
Did you guys hear that sigh? Okay, hold on. Let me read this.
There's the important part.
Kind of reminds me of Shiro. Shiro would do like.
Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case.
Why are you reading so fast? Hank, slow down. I can't type that fast. Ah!
Who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Lisi no longer likes the word retain, but that retain word has import. There's a reason we said it. Their words, their motion. This is no different than the tone of representations made February, last June, May, and before. Thank you.
All right. So we're back here next week. I believe we're back here
Oh.
Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court
What
at
time?
9:30 in the morning.
Okay.
Could we possibly go there and then
Yes.
come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay.
No! I want to know what happens. That's it? I mean, a lot happened today. Jesus.
All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday. All right. So
Sorry, when is he going to federal court? He said Wednesday, right? Okay, so Wednesday. I want to know what. I don't want to wait. Oh, gosh.
see you next week.
Okay, Wednesday. What day is Wednesday? How did you get your calendar on your desktop to show up? I'm clicking on the time. The calendar ain't showing up. Oh, it's because the second monitor. Okay, so the 5th. Wednesday the 5th. Okay. Janetti will come after federal court. But does that mean that they're going to start after Janetti and Jackson comes, right? I think so. Janetti and Jackson will come after federal court. Right? They're going to start late, right? Oh, gosh, what a day. What a day. I don't think I'm going to make a video recapping today, though. That was a lot. That was way too much. Way too much. Yeah, I'm not recapping this. Jesus, this is so crazy. I can't wait to be back next week. It's like when you're watching your TV show and it's like, oh, it's a cliffhanger. You got to wait a whole last week for you to come back. Huh. I don't know. I think Hank Brennan ended it. Jesus. He kind of mic dropped that for a second there. He was like, well, okay. I mean, they did file a motion recently where they said there's no payments made to ARCA and that these witnesses are, what did he say? Unbiased or something like that? I don't know. I'm so lost in my notes right now. Blah, blah, blah. I wrote too much shit. The substance, the source, not the substance. Nope, wrong. 3 experts. Oh, yeah. They said that, I don't know if they revisited something about the 3 experts. They're like, oh, the 3rd expert was actually Dr. Marie Russell, not ARCA. I don't know if they went back and addressed that. But, oh, here it is. Okay, so the defense filed a motion This was on February 16, 2025. Oh my God, that was like 10 days ago. And that's where we heard the big sigh from Judge Canoni. It was signed by Jackson, Alessi, and Yannetti. CW motion to exclude the witnesses who were not hired or paid by the defense. Is not made in good faith in a desperate attempt from keeping a neutral expert witness. ... I couldn't get the rest of it because I was speaking too fast. Jesus! All right, we'll have to come back next week. I mean, I think we're going to be here bright and early next week. Oh my gosh. Well, I might start it a little bit late though because I like catching up with them. Well, actually, it wasn't that bad today. It wasn't that bad because during the lunch break, I just took a lunch break too. Jesus. How are they going to explain this away? And then also, man, Alan Jackson shouldn't have said anything to the reporter. Should have just kept on walking. Just kept on walking. Oh boy. All right, guys. Well, that's it for today. Jesus. Yeah, that's it for today with the Karen Reed stuff. Back and forth, back and forth. We'll see what happens. I don't know, man. I think at the end of last week's hearing, I thought Judge Canoni was, thinking of some severe sanctions, or she was going to do something. And then when we came back today, and then as Alessi's explaining, I'm like, oh, maybe it won't be that bad. Okay, maybe it won't be that bad. But then now, I don't know. I think the way, listening to her tone, all the sighings, I don't know. I think she's considering something that might be bad for Karen Reed's defense team. I don't know. That was something. Dude, that was crazy. That was wild. Oh, man. And I don't even know how to even recap this because it was just so much shit. So much information. Towards the end, it just became a little bit scrambled, in my opinion. But we had the timeline. I think the timeline was good to show that there was communication between defense and ARCA. They were trying to maybe hire them or something, but then there was a pause. They weren't allowed to. And then ARCA was just going to come in and just like testify for the defense, I guess, without the expectations of getting paid. Coming in, they were going to pay for their own expenses. I don't know. I don't know if ARCA thought that they were just going to bill it to the federal government, but that wouldn't make sense because this is not a federal government case. At this point, this is a state's case. But maybe ARCA was just like, oh, we could just bill the federal government for this. I don't know. And then when they couldn't, they billed the defense instead. I don't know. That doesn't make sense to me, but maybe that's what happened. But Canoni didn't talk anything about getting the ARCA people to come in and testify. So maybe we won't hear from them. Jeez. But yeah, so like I was saying, timeline was good to establish how things went down. Although Hank Brennan thinks that there are some communications that hasn't been divulged yet. He thinks we're just at the tip of the iceberg. But communication was shown that, okay, so we had communication with Jackson, with Dr. Wolf. It got halted. It was paused. And then voir dire happened. After the voir dire, we got the email where there was the outline with the notes in the margin where he was like, oh, hey, if you don't want me to mention this, I won't mention it. And then the testimony happened. After the testimony, the defense claims that they got a surprise bill from ARCA. And it was like $24,000. So expenses, travel, and all that stuff. Now, the issue that I think the major issue for the defense really is the fact that they filed that motion recently in response to the Commonwealth's motion to exclude the ARCA witnesses. They filed the motion they did a response and they said that the witnesses were not paid or hired by the defense and that these are neutral expert witnesses. Man, I think that could be a huge issue for them. And then also Attorney Jackson telling the reporter that when they're like, oh, did you pay for their testimony? And he says, of course, no, of course not. I think that could be an issue too. And what's another issue? Was there another one? I don't know if there's another one. Oh, and then, yeah, the other issue was how did they know which expert did what? There were 3 ARCA experts. And then if you look at Judge Canoni says that when she looked initially at the report, you couldn't tell who did what. So how were they able to coordinate who was going to testify? Who had knowledge of, that what experiment they did? I don't know. But you see, the issue with Hank Brennan was his misrepresentation or his mistake in saying that it was provided by the federal government, not the experts, or not the defense. He said he quickly corrected that. But he says it's not about the source, it's about the substance of what went down, which is what I mentioned before. I don't know. That's pretty much about it. I'm sorry. It was just like I just felt like it was just like a vomit of information that just happened. It's so hard for me to recap all this, but I don't know. That's just basically the gist of it. So we're going to wait to see what happens. Next week, we have 2 full days. And I don't know. They haven't called ARCA yet. So I want ARCA to come in. Bring the ARCA, guys. All right, guys. I don't know. I feel like I'm so excited for this. All right, guys. I hope you guys have a good day. Take care. I think we are going to be here tomorrow, though, for Donna Adelson's hearing. So if you guys aren't caught up with Donna Adelson, I posted a video last week just to recap everything that's going on with Donna Adelson. She wants to be out on bond. She said that she's been bullied by other people in the jail, and she has medical issues. She doesn't have access to like proper medication, and like she has her sensitive ear hole canals that needs to be cleaned out by a special ENT every 3 months, and she doesn't have access to that. And then there's some other issues that she has. So she wants to be out on bond until the trial happens. I don't know if that's going to happen because she's like, oh, you know, I'm not at flight risk. You guys took my passport away. Yeah, but you're also probably rich as fuck. And maybe there's ways for you to get the fuck out of the country. I don't know. But they're going to have a bond hearing tomorrow. And we'll figure out what happens with Donna Adelson. But she has her trial scheduled for, I think, May. Is it for May? I think it's for May. And if I remember correctly, Donna Adelson, they live stream her shit, right? Is it live stream or is it like Corey Richards where they'll have the hearing happen and they'll release the footage afterwards? I think Adelson is live stream. So tomorrow her hearing's gonna happen at 9 a.m. I'm hoping to cover that. So I will see you guys tomorrow. And I'm gonna go catch up for Corey Richards as well because there's a lot of stuff happening in Corey Richards and I haven't caught up on that one yet. I was catching up on Adelson, but there's been so much shit that's been coming out about the Blake Lively and Justin Baldoni stuff that I'm just like, oh gosh, I don't know. I'm just like, I don't know if I want to cover it day by day. It's just too much shit that's coming out for that one. So I'll just wait until like the big stuff happens maybe, or I'll just do like recap stuff. We'll see. But yeah, I will see you guys tomorrow. And guys, I appreciate you guys being here. I hope you guys have a good one. Bye, Richie. Yeah, I hope you guys have a good one and take care. I will see you guys for Adelson tomorrow. And yeah, that's it. That's it for me. All right, guys, take care. Take care of yourselves.